Please be seated. The sitting is now open. The court meets today to hear the second round of oral argument of the Russian Federation. For reasons duly made known to me, Judge Benuna is unable to be present on the bench this morning. Before I give the floor to the first speaker on behalf of the Russian Federation, I'd like to mention that shortly before the start of this hearing, the Russian Federation provided to the court some materials in which the Russian Federation raised some matters that it considers to have implications for the administration of justice. Those materials will be available to the court and to the other party in written form, and the other party will have an opportunity to comment on those materials in written form. The registry will inform the other party of the time limit within which it may make such comments. I now call on Mr. Michael Swainston. You have the floor, sir.
An honor to appear before you on behalf of Russia to respond to Ukraine's further submissions. We heard a great deal in Ukraine's opening submissions about Russia's alleged contempt for international law and also for this court. I need to tell you that in response to my last submissions before you, I have been faced with a death threat on Mirat Vorets, hosted in Langley, Virginia.
Excuse me, Mr. Swainston. It was my understanding that these matters which were provided to the court would be covered in written form by the representatives of the Russian Federation today.
Madam President, I'm grateful for that indication. I hope you understand, given the circumstances, why I felt the need to mention that in open court, because it affects me immediately and it potentially affects all of the advocates for Russia. It is directly relevant to the proceedings before you, and in my submission, it bears upon the credibility of Ukraine's position. When they talk about conspiracy theories and so on, if there was nothing in them, if there was no substance, it wouldn't be necessary to suppress them.
Mr. Swainston, the court has the materials that were submitted in writing. The court will consider them. The other party will have an opportunity to respond to them. And I ask you kindly to continue with the other aspects of the case that you wish to present on behalf of the Russian Federation, please.
I turn to MH17, and I will cover this quickly because little in substance was said. Ms. Zolotaryova said that Russia's position was conspiracy theories and baseless propaganda. Ms. Cheek said that Russia was guilty of dredging conspiracy theories from the darkest corners of the internet. With respect, Ukraine has it wrong. The darkest corners of the internet are where Ukraine claims to have found its digital evidence. On social media accounts that disappeared immediately after these things were produced, then, supposedly, they were raised to general awareness by the likes of Bellingcat. The original digital files still lurk in dark corners somewhere because they have never been produced. Russia has asked for the original digital files for years, and we have never seen them. And Ukraine has chosen to try to prove a digital case that the Buck TLAR came from Russia and returned again without producing a single original digital file. When we did find one, the Snizny video, it was no thanks to Ukraine. It was obviously fake for the reasons I gave in my previous submissions, which evidently produced some consternation in some quarters. Now, Ms. Cheek did not deny that Ukraine has failed to make available the original digital files. Ukraine has not done so here. It did not do so in Strasbourg, the only places where Russia is a party. Indeed, it is increasingly clear that there were no original digital files in any conventional sense, because Ms. Cheek had no answer as to why the Australian Federal Police Forensic Department could not have them in 2015 when they're supposed to have existed since July 2014. Why not simply produce them if they exist? Why not produce all the digital files with metadata? Instead, to coin a phrase, Ukraine has done nothing. But Ms. Cheek said there were checks. Ukraine relied on the admissibility decision in Strasbourg, at Ukraine's slide 20 for that proposition. Please note that was an admissibility decision. It establishes nothing. Ukraine relies on the report that there were checks by the JIT. But how could the JIT check without the original files? Australia was a member of the JIT, and its police department couldn't be given the original files. Then, Ukraine cites consistency of its case with the Atlantic Council, Bellingcat, and Inform Napalm. Slide 2, the Atlantic Council is NATO's propaganda wing, and it is financed by the US Defense Department, amongst others. Bellingcat, we saw last time, has secret links, now no longer secret, to the UK Foreign Office through obscure Scottish charities. Inform Napalm was said to be a serious and credible organisation. You may see in material that you have that it was set up by Mr. Tuka alongside a site called Mirat Vorets, which issues death threats. It is a tool of information warfare. It is in no way an objective or credible source. But we are told that the likes of Bellingcat are credible and serious. With respect, it is incredible and ludicrous to suggest that Russia is bound on facts by what they say. Then at Ukraine's slide 21, Ms. Cheek referred to the Hague Court and a reference to supposed checks there. It raises the question, checks on what? There's no evidence that the court actually saw itself digital material. I've been Russia's advocate on MH17 throughout Strasbourg and here. I have not seen a single digital file from Ukraine. On the same slide 21, Ukraine says that the Snizny video was checked by Swedish forensic experts. Again, that is not a check to which Russia was a party. But anyway, there's no Swedish forensic report so far as we are aware. It wasn't in Strasbourg and it's not here. And we also know there were no forensic checks. If there had been, the pictures would have been seen to be manipulated if the copies provided to the Australian police are the ones we're talking about. The date problem with the Snizny video would have been found, together with the issues on provenance and Elliot Higgins. The other problems found by Russia's forensic expert would have been discovered. The vertical line, the horizontal line, the problems with shadows and improving quality in separate versions over time. On intercepts, the date problem would have come to light. It would have been obvious that the SBU faked the Besler intercept using a previous intercept to do with a Sukhoi bomber. Notice that Ukraine's advocates were very careful when they talked about checks. They did not suggest the Swedish report or anything else addressed the points that Russia has made in Strasbourg and here. It's highly regrettable that the Strasbourg judgment does not summarize, let alone deal with, most of those points. That was not open justice. And I commend to you a speech of Lord Toulson on the importance of open justice. The whole speech is very worthwhile, but those are the key points. Why can't Russia see primary evidence? I seem to have missed the rule of public international law that says against Russia, you do not have to produce primary evidence and prove its provenance. Don't worry, Russia is bound by the likes of Bellingcat. I turn briefly to physical evidence. Please note that Ms. Cheek said nothing whatsoever about the points I made on physical evidence on the DSB report. Those did not come from dark corners of the internet where Ukraine found its digital case. All of them were bright and clear on the pages of that report. As things stand before you, there is no explanation why the DSB did a fictional triangulation. There is no evidence on the provenance of bow ties. There is no evidence on the provenance of wreckage from the port side of the cockpit. There's no investigation of any of these things, including the complaint of Mr. Bukurcu, the OSC investigator, about people hacking away at the cockpit. There is no evidence of proper investigation of explosive traces or why the DSB was coy about PETN. There is no consideration of the evidence from Dutch military intelligence that there were no buck TLARs in range. Now, just on that, we went to a Dutch military intelligence document, and it was suggested we got that from a blog. The European Court of Human Rights made the evidence secret in that case, so I can't show you, but I can tell you that the Netherlands confirmed the authenticity of that document. Note on it an extra point. Ukraine said on Monday that the references were references to complete buck systems, including command center and radar. Note that the same reference is given to Russian systems said to be in theater. So if those are complete systems, there is nothing to support the fictional lone buck TLAR on which Ukraine relies in this case. Finally, slide 11. If Ukraine relies on the JIT, notice the JIT says in its latest report that the buck TLAR was not operating entirely on its own because Russia was supposed to supply radar data to the DPR. That means it was even more discriminating as a weapon, but in any event, even on its own, as Dr. Skorek said, an experienced buck TLAR commander and operator can fairly accurately identify the target. That is not an indiscriminate weapon. I turn to intent. Russia has made its submissions on the intention required under the ICSFT. We've demonstrated from the express words that specific intention is required at the level of the funder and of the funded terrorist. We have shown that there is an implied or express exclusion of military activities throughout the ICSFT, the Montreal Convention, and the ICSTB. All of the issues of interpretation have been addressed in detail in our written submissions. We can't repeat them here. We commend them to your attention. For now, I will respond to certain points taken by Professor Tuvinin. First, Professor Tuvinin complained that Russia referred to the ICSFT as requiring specific intent, but he said specific wasn't there in the treaty. We used that phrase, specific intent, specific direct intention, to distinguish what we say is necessary from all the varieties of attenuated intention that Ukraine has sought to introduce. You see them there, with no supporting words whatsoever. By contrast, for the reasons given in our previous submissions, the plain words set out what is required, and it is specific and direct intent. First, the funder must intend that the funds should be used for a terrorist attack that fits an offence in the treaties in the annex. We saw that those are terrorist offences requiring specific intention themselves. Alternatively, the funder must know that his money is to be used for one of those offences. In the further alternative, the funder must intend or know that the money is to be used for a catch-all terrorist act in Article 2(1)(b), a terrorist act intended to kill or seriously injure civilians or non-combatants with the purpose of terrorizing a population or influencing a government, etc. But then Professor Tuvenin tried to weaken the plain words. He started with willfully in Article 2(1), and he said that it was there to exclude physical extortion of money from the funder. It had to be a voluntary provision of money. He rejected Russia's submission that it doubled up on the express requirements for intention or knowledge of the funder. But with respect, Professor Tuvenin's approach does not work. If there is any doubt on the point, we had the travaux, and we had the slides 3 and 4 in our earlier presentation. Professor Aust explained why willfully was there, and it was to emphasize specific intent in relation to the funding. Specific intent and knowledge in Article 2(1). And also, please consider this. If the funder were blackmailed or funds were extorted, he or she would still be providing money deliberately, even if they didn't want to, potentially with knowledge of an intended terrorist attack. If the drafters had wanted to exclude that case, there would be an express exclusion. And consider the possibilities otherwise. The funder is blackmailed into providing money which is used to kill thousands of people in listed terrorist crimes. His provision of money in these circumstances would be caught if he knew the terrorist purpose, and so it should, because blackmail or extortion should only mitigate the sentence. In most legal systems, duress is no defence to murder. That's the Old English authority that we cite at slide 5, that still expresses the principle in the common law world, but the position is a general one in civil law states too. So willfully emphasises requirements of intention and knowledge. It has nothing to do with extortion or blackmail or similar. I also note that remarkably, when Professor Tuvenin read down willfully, he contradicted Ukraine's own submissions about its meaning. Previously, Ukraine stressed that the Tribunal for the former Yugoslavia and the ICRC define willfully as synonymous with intentionally and meaning to act consciously and with intent. Next, Professor Tuvenin referred to an alleged error number 4. Instead of specific direct intent in relation to the terrorist act, he introduced his own concept of an act destiné à tuer. Intention was satisfied by objective criteria, he suggested, like the nature and context of the act. But this reflects Ukraine's consistent mistake of trying to expand the objectivity in special political purpose to the areas covered by specific reference to intent. As we submitted earlier, the reference to nature and context of the act in the context of special political purpose is a unique inclusion there. Otherwise, the ICSFT speaks of intent. It's important to avoid confusion on this. There may be objective evidence that suggests intent, and it may be used to prove intent, but that does not detract from the need to prove intent as direct, specific, subjective intent. Obviously, the prosecutor will look at objective evidence to try to prove intent, but that does not mean that intent is an objective concept. It is specific, direct, and subjective. Now, as we submitted previously, the funder's intent in Article 2(1) must take in the terrorist's intent. The reason is that under 2(1)(a), the predicate terrorist offences require specific direct intent. Under 2.1b, the terrorist must similarly have terrorist intent to kill or seriously injure civilians or non-combatants with a special political purpose. This is entirely normal in criminal law. For example, in every aiding and abetting case, it's necessary to know that the person abetted intended to commit the crime, including crimes of specific intent like murder. You can't aid and abet murder without knowing that the perpetrator intends to kill somebody. That is an entirely general concept, and we see that from the ICC statute at slide 7. We see how it defines mens rea, and I wonder if I could ask you just to read that. Summarizing, generally, intent and knowledge are required for the material elements. Person has intent where that person means to engage in the conduct, means to cause a consequence, or is aware that it will occur in the ordinary course of events. And then at slide 8, we've got Article 32, which further states that a mistake of fact, in other words, what we have on the MH17 case, and what we also have in cases of mistaken targeting, shall be a ground for excluding criminal responsibility if it negates the mental element required by the crime. Next, Professor Tuvinen's point 5, he says that knowledge of the subjective intent of the terrorist is not required because the terrorist may not commit an act within 2.3, but with respect, we explained earlier that it's knowledge of the terrorist intent, precisely that makes funding dangerous. The crucial question is, what would a funder know in our case when transferring funds to the DPR or LPR? Would they know these are terrorist organizations, on Ukraine's case, perpetrating terrorist crimes? Clearly not. They'd been defending their people. They had not been designated as terrorist bodies by any competent international body, such as the UN Security Council. No state had designated them as such, including Ukraine. On the contrary, Ukraine dealt with the DPR and LPR in the Minsk agreements and traded with them. Ukraine relies on one line in an OHCHR report about reign of terror. But the same report saw Ukraine's anti-terror operation as causing the climate of fear. Any funder would know about the conflict, and such conflicts inevitably cause loss of civilian life. They don't point to terrorism. So next, Professor Tuvinen's mistake 6, his rather than mine. He objected to Russia making the ICSFT subject to IHL. But we've consistently pointed out that the ICSFT does not apply to military acts in the context of conflict, and there were many reasons for this which Professor Tuvinen did not address. He did, though, refer to Article 21 of the ICSFT. See the language on slide 9. Now, please, note Article 21 contains a clear do not affect clause, which according to the VCLT and the ILC signifies the prevalence of other bodies of law over ICSFT. In other words, here the precedence of IHL. And we've given you at slide 10 and 11 the VCLT and commentary. This is critical because Ukraine admitted that IHL does not criminalize as terrorism the killings of civilians in conflict, where, for example, there is a mistake of targeting. But Ukraine says, under the ICSFT, it's unlawful to finance such acts. With respect, that is not sustainable. If an armed conflict is governed by IHL, there is no terrorist and no predicate offence of terrorism. Of course, this fits with our submission that ICSFT has nothing to do with acts in armed conflict, and I won't repeat those. Ukraine suggests the ICSFT covers acts governed by IHL which violate governed by IHL which violate IHL. But as the Hague Court said, and even the JIT, there was no war crime here because there was no intent to kill civilians in relation to MH17. The findings of the Hague Court demolish Ukraine's current case. They found no terrorist intent, no terrorist offence, and no finding that the DPR, LPR were terrorist organisations. The JIT said there was no scope for war crimes. Now, Mr. Udovichenko will deal with other particular alleged incidents, but IHL itself regulates situations of targeting civilians. Relevant war crimes applicable to a non-international armed conflict, as Ukraine qualifies the conflict in Donbass, are listed in the ICC statute, and they include intentionally directing acts against the civilian population as such, or against individual civilians not taking part in hostilities. So there is no scope for regulating under the ICSFT matters in conflict which are governed by IHL. And if the ICSFT did apply, there could be no basis for applying a lesser standard of intent than required for a war crime. And please note on that our reference to the Katanga case in our counter memorial at paragraph 238. In that judgment, the tribunal looked at the required intent and said that it did not include dolus eventualis, awareness of the existence of a mere likelihood or possibility. They referred instead to oblique intent, meaning virtual certainty, and they said this form of intent presupposes that the person knows that his or her actions will necessarily bring about the consequence in question, barring an unforeseen or unexpected intervention. Ukraine is nowhere near this standard on any of the incidents on which it relies. Now, a word on the Montreal Convention. Madam President, I'd ask for about 5 minutes more, if I may. Professor Tuvinen's seventh mistake. I've already made submissions on the Convention, pointing to the title, preamble, and Article 4. Professor Tuvinen noted the references to civil aviation rather than a civil aircraft. Well, we submit that's a distinction without a difference. Then he said that everything turned on use, so that a military aircraft could be civilian if it were on civil charter. But that, with respect, is hopeless. A plane with military markings could easily be shot down over a zone of conflict consistently with IHL. And please note that according to the ICAO, one of the criteria used to determine whether an aircraft is used in military service is whether the aircraft will fly to or over areas in a situation of ongoing armed conflict. See slide 12. There would be no terrorism in such a case because there would be no intention to shoot down a plane carrying civilians. We explained previously how intent is tied up with the civilian character of the aircraft in the Montreal Convention. Overall, Professor Tuvinen said nothing to get over the problem we identified on the language of the ICSFT, the listed conventions, and Article 2.1b. They require specific intent and they do not cover mistake. There's no offence of providing funds knowing that the recipient may commit a terrorist offence or terrorist act by mistake. It makes no sense because mistakes don't qualify those acts. Nor is there an offence of providing funds to one side in an armed conflict knowing that they might use the money for fighting. That's what parties in an armed conflict do. They're not terrorists per se. And we saw in my earlier submissions that there's an implied military exclusion. Professor Tuvinen said there's no basis for that. There is, as we indicated, with lots of reasons that weren't answered, and Professor Sinho Yi will address this further. For present purposes, even if we put aside the military exclusion, the ICSFT does not apply in situations of armed conflict because, again, of the requirement of terrorist intent on the part of the supposed terrorist. 2(1)b requires an intent to kill or injure civilians or non-combatants, and there is no such intent when civilians are killed by mistake in the course of an armed conflict. There is no intent in armed conflict if people are not specifically intending to the IHL war crime standard of killing civilians. Now, these points defeat Ukraine's entire case, its case on MH17 and its case on alleged shellings and bombings. Ukraine has failed to show intent. Ukraine has failed to deal adequately with the exclusion for military activities. A last point on provision. You recall I pointed out that there was no provision of the Buck TILA because Ukraine seemed to have forgotten its case that there was a Russian crew. I emphasize again, all of this is fiction. This did not happen. No Buck TILA came from Russia or returned. But that is Ukraine's case. And on that basis, all the rebels did was ask for air cover. The only thing provided was air cover. Air cover is not funds or an asset of any description. Professor Tuvenin said there was temporary provision of the buck, but that ignores the custody and control point. On Ukraine's legal case, the rebels couldn't tell the crew to shoot down a civilian aircraft because the Buck TILA was not provided to them and they were not in it. In any event, on Ukraine's own case, the rebels didn't instruct the crew to shoot down a civilian plane. Even if we believed their evidence, they only asked for air cover against military planes. Then there was an accident, and that is not illegal under IHL. It's also completely outside the ICSFT, its listed offences, and Article 2(1)b. Madam President, I'm grateful for your indulgence. I thank you for your attention, and that applies to the whole court, including all of the distinguished judges. We, the advocates before you, depend on that attention.
I thank Mr. Swainston, and I now give the floor to Professor Hadi Azari. You have the floor, Professor.
Merci, Madame la Présidente.
Thank you, Madam Chair. Madam President. Madam President, honourable members of the Court, I come again before you to discuss once again something that is or should be an obvious fact, but that Ukraine denies over and over again. That is that arms, weapons, arms of war are not funds as we understand them, whatever the definition. And it's not by looking at the French version of the convention, as you were shown it on Monday, that you can challenge this obvious statement. Indeed, to support this case, the Ukrainian party has no hesitation in going against all the interpretation rules set out in international law as codified in the 1969 Vienna Convention when it looks at the word funds. Ukraine doesn't even deny that. Rather than looking at the ordinary meaning of the word funds, it is asking you to go along with a particular meaning, the one that serves its needs. Rather than looking at the object and purpose of the convention, by looking at the preamble or the title of the treaty, as you have suggested, as your court has suggested in other cases, Ukraine is asking you to reject without justification these sources of interpretation and only rely on an extract of the article that it will have identified. And rather than looking at the context of the article at hand, Ukraine continues to treat it in isolation without acknowledging the inconsistency that this alleged definition of the word fund would have vis-à-vis the other provisions of the convention or vis-à-vis its use in general international law. And let me look at these items separately and successively. First of all, yes, it is possible for a text to have been understood in a particular way if it is established that such was indeed the intent of the parties. But this is not the case here. You just have to look at the other authentic versions of the convention, which the Ukrainian party ostensibly neglects. And they are, however, meant to have the exact same weight as the French text. Look, for instance, at the English version of the text, Article 1.1 here on the screen, which also defines the word funds. It does not refer to the notion of goods, which would have been able to refer to any bien in French, but indeed to assets. So assets that belong to a person or a company, regarded as having value and available to meet debts, commitments, or legacy. The Russian version, which is just as official, is also enlightening in that it also illustrates the very same nuance. And indeed, the French intention was not to give a specific meaning to the word fund. That is what we saw last Thursday when we looked at the travaux préparatoires as submitted by France in the run-up to the negotiations of the convention. And seeing as Ukraine does not find this source as being conclusive, you just have to look at the way the the French Minister of Foreign Affairs introduced the bill for ratification of the ICSFT. At that point, the minister said, and I quote, "First of all, we have a broad definition of funds. These include the assets of all nature. Assets, avoir in French, not bien, not goods. And legal documents or instruments in any form which establish a title to or interest in such assets." End quote. So it is the ordinary meaning of funds which all the parties to the convention wish to refer to. And this ordinary meaning does not include any goods, but only just the financial or financially related assets, a definition that does not include weapons. The second branch of the Ukrainian analysis is also baseless. It relies on a textual analysis of Article 1.1, which would lead to the distinction or the division of funds into two categories. The first one, in red here on the screen, is very broad, in that it covers assets of every kind, and the second version, in green on the screen, includes titles, interests, and examples. Now, the problem is that this presentation is just wrong. The division in Article 1, Para 1, is not where you would want to find it. The Commonwealth Secretariat, in its implementation kits for the International Counterterrorism Conventions, explains how the article was drafted. After, first of all, mentioning that the definition of funds was drawn deliberately wide so as to leave no loophole for bankers to exploit, and bankers here, not arms dealers, the kit then comes back, or the fact sheet then explains that the first general part of the definition was taken from Article 1G of the Convention Against Illicit Traffic in Narcotic Drugs and Psychoactive Substances of 1988. Article 1Q of the Convention, which defines the word property in English, bien in French, is indeed exactly the same as Article 1.1 of the ICSFT. But it does not include, as you can see here, the examples included. There's only one conclusion. Having lifted the general definition of bien, or property, the drafters of the ICSFT have adapted it to restrict it by adding to the word fonds or funds a list of examples, and this list is therefore restrictive in purpose, so that we now only relate to the financial assets only. So it is indeed the ordinary meaning of funds which has been the one used by the drafters of the ICSFT in accordance with the object and purpose of the treaty. Now, let me be brief on this last item here. The context in which Article 1.1 fits, which was in fact completely avoided by Ukraine last Monday. Let me just recall that Article 1 aims at setting forth the definitions of the words to be later used in the treaty. The definition of funds, which you find in that article, must therefore be consistent with the other provisions of ICSFT where it appears. But this is clearly not the case if you replace funds by arms, which Ukraine seems to think would be possible, or should be possible. For instance, you cannot derive arms directly or indirectly from the commission of an offence. You cannot freeze arms, a sanction which is in fact usually related to economic resources or financial assets. And lastly, it is hard to imagine that states parties would look at sharing the arms confiscated from terrorists. Therefore, the particular meaning which the Ukrainian party considers should hold, does in fact make no sense. And again, it is the ordinary meaning of funds which enables us to understand the definition of Article 1.1 within the broader context of that specific international instrument. It's an ordinary meaning that you find in other contemporary sources or related sources to ICSFT. Look, for instance, at the United Nations Security Council resolutions relating to the fight against terrorism. For instance, Resolution 1373, which I mentioned last week, or the Security Council Resolution 2199, which establishes a clear distinction between the financing of terrorism and the supply of weapons to terrorism. In this case, the notion of funds is only mentioned with the first prohibition, not the second. Therefore, the drafters of ICSFT intended to give a broad meaning to the idea of funds, as the French Minister of Foreign Affairs and the Commonwealth Secretariat of State. Yet to claim that it would cover everything under the sun alters both the express and implicit will of the parties, of which Russia is, to suppress the financing of terrorism and only financing. Ladies and gentlemen of the Court, the Convention of 1999 is not a general convention on terrorism. It is merely one of the conventions, and there are 13 all in all, which cover various aspects of terrorism. In this instance, the financial aspect. Other conventions deal with other aspects of terrorism. For instance, the International Convention on the Suppression of Terrorist Bombings from 1997. It deals, as the title clearly indicates, with the suppression of terrorist bombings. This convention considers explosive device as a weapon under Article 1 and prohibits its delivery in Article 2. I have finished with my presentation. I'd like to thank you for your kind attention, and Madam President, I would ask that you call Professor Sin Ho to the bar.
I thank Professor Azari, and I now invite Professor Sin Ho Yi to address the Court. You have the floor, Professor.
Madam President, distinguished members and judges of the Court, I will now respond to Ukraine's argument regarding the relationship between ICSFT and IHL. More generally, as you have heard, Mr. Swinston already said quite a few things about it. On Monday, Counsel for Ukraine tried all his best to get IHL out of ICSFT, but to no avail, I would say. First, Counsel said that some concerns were raised, but they related to humanitarian aid, insinuating that no other concerns were raised. And worse, deliberately exaggerating points or putting things we did not say in our mouths. But the very piece of jotting history that Council for Ukraine cited has this paragraph, which in my view clearly shows that humanitarian concerns other than humanitarian aid were raised. I quote, "A further point was made that the reference to civilians have been included since it was agreed that a certain category of persons should never be targeted. However, it was also necessary to cover another subset of persons, namely those who were not civilians but who were not engaged in armed conflict either. Examples included off-duty military officers. To accept a broader definition would involve difficulties with the application of humanitarian law and could lead to the situation where certain acts would be classed as terrorism when they would be acceptable under humanitarian law." End of quote. Thus, humanitarian concerns other than humanitarian aid were not only raised, but also reflected in the final text of Article 2(1)(b) of ICSFT. Council for Ukraine also blamed us for saying that downplaying the importance of IHL, as Ukraine does, would disincentivize non-state actors from complying with humanitarian law. He said, "This is untenable." Of course, it is easy for Council to say this from the ivory tower, but an entity none other than the ICRC, who deals with realities on the ground, just uses the words "likely" to diminish any incentive to comply with IHL to express our idea. Of course, our statement was inspired by the ICRC's view, not made out of speculation. Furthermore, Council for Ukraine himself referred to other anti-terrorism conventions which contain military exclusions, showing that this is considered normal practice by states. Second, Council for Ukraine argued that there was no conflict between ICSFT and IHL because ICSFT merely describes certain acts not to be financed and does not define terror. That's a mechanical reading of the convention, and it is incorrect. The ICSFT no doubt defines terror, although it does not use this word in Article 2, but the entire ICSFT as a whole and the title make it very clear that the acts Council said were merely described are no doubt defined as terror, as a component in the composite act of the crime of financing terror. Indeed, Article 2(3) refers to those acts listed in Article 2(1)(a) and (b) as offenses. I quote, "For an act to constitute an offense set forth in paragraph 1, it shall not be necessary that the funds were actually used to carry out the offense referred to in paragraph 1, subparagraph A or B." End of quote. This is also how it is perceived in state practice. For example, according to the Dutch Penal Code, which Ukraine itself mentioned, acts falling under the definitions of Article 2 of the ICSFT are considered terrorist offenses. Third, Council for Ukraine said that the link with armed conflict is dealt with under Article 2(1)(b), and the acts listed there are not criminalized under IHL, or IHL does not criminalize this type of act of terror. And that provision should not be interpreted strictly. Well, all we can say that this approach reads Article 2(1)(b) in isolation, as an island in and of itself, and takes Article 21 out of the Convention, which is against all tenets of treaty interpretation. But Council was correct in recognizing that IHL does not criminalize the acts listed in Article 2(1)(b) as terror in an armed conflict situation, and precisely this calls for giving play to IHL in the interpretation and application of this provision. The acts are acts of terror in times of peace, but not in times of war. In situations of armed conflict, the primary purpose to spread terror is necessary for those acts to qualify as war crimes of terror. Fourth, Council for Ukraine argued that Article 21 of the Convention is merely a no prejudice clause, and if there's a conflict, the Convention prevails. This article contradicts the plain language of Article 21, which states that nothing in this Convention shall affect other rights, blah, 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 blah. In particular, international humanitarian law, this nothing shall affect language is very similar to that used in VCLT, Article 32, and the ILC commentary there too, to give priority to another treaty. Indeed, the ILC commentary uses not to affect, just like that in Article 21, to express this very idea. Counsel for Ukraine insisted that there is no possible incompatibility because, in his view, ICSFT has no bearing on the obligations and responsibilities of individuals under IHL, since it does not incriminate acts in Article 2(1)A and B. It merely designates them as non-financeable. While it is true that ICSFT does not criminalize those acts as separate crimes, it does designate them as components in the composite crime of terror financing, as mentioned above. And these acts are special acts, and they play a role in making the composite crime of terror financing special, unlike any other crime. For this reason, subparagraphs A and B are no mere simple descriptions. If Article 2(1)A and B is not interpreted so as to be consistent with IHL, it may criminalize, in a situation of armed conflict, acts that do not rise to the level of war crimes of terror, and would affect a suspect's rights under IHL to receive support in his or her armed struggle, presenting a conflict between ICSFT and IHL, which is just one example. There may be other possible conflicts. Furthermore, the general obligation of states to ensure respect for IHL may also be interpreted as prohibiting financing of war crimes or terror, as the ICRC says. And we may conclude that the IHL also addresses financing of war crimes or terror in a general way. Counsel for Ukraine also attempted to prove our interpretation of Article 21 as untenable by resorting to Article 4 of the International Convention on the Suppression of Acts of Nuclear Terrorism, ICSANT, saying that Article 4(1), which replicates Article 21 of ICSFT, will apply to situations of armed conflict, as Russia argued, but Article 4(2) excludes application to armed conflict situations. Counsel concluded that a convention cannot both apply to situations of armed conflict and not apply to situations of armed conflict at the same time. There is a simple error in counsel's reasoning. Article 4(1) and 2 are not coterminous, and therefore there is no problem at all. Article 4(1) is a general provision indicating that application of ICSANT in armed conflict situations cannot contravene IHL, while Article 4(2) entirely excludes a specific category of activities and or persons from the application of the ICSANT, leaving them to the coverage of IHL only. There is thus room for both Article 4(1) and 2 to have effect. Fifth, counsel argued that the court's reading in nuclear weapons does not apply because no act is governed by both ICSFT and IHL. I have already elaborated above that Article 2(1)B of ICSFT and IHL may both apply to war crimes or terror in armed conflict situations, and this, under the court's teaching, would constitute terror and a component of the composite crime of terror financing on Article 2(1)B is to be determined by the applicable IHL. This will also obtain with respect to other possible similar scenarios, in particular where the war crime mens rea is required. Finally, just a word about implied exclusion of military activities under the Montreal Convention. Again, Russia does not claim originality on this point, as Ukraine accepts. It is the position of the Legal Committee of the ICAO. Comparable UN counterterrorism conventions concluded after 1997 contain a military exclusion clause, which expressly specifies that conventions do not govern the activities of armed forces during an armed conflict and the activities undertaken by military forces of a state in the exercise of their official duties. In ICAO, it has been widely understood that the aviation security instruments which criminalize certain acts are not applicable to the military activities mentioned above. The same clause of military exclusion can be included in any instrument amending the conventions in order to achieve uniformity and clarity and to prevent any interpretive confusion. Such a clause would be considered as declaratory in nature. The military activities of armed forces are now usually considered falling within the scope of such activities of armed forces, as long as they are organized and operate on the basis of command responsibility. This finds support in a variety of authorities. The Hague District Court, for example, routinely refer to DPR forces as armed forces and organized armed groups falling under the IHL definition. In light of the above, Counsel for Ukraine's arguments on the relationship between ICSFT and IHL are without merit. I've come to the end of my presentation on this point. May I invite you, Madam President, to give the podium to Mr. Udovichenko to continue Russia's presentation. Thank you for your attention.
I thank Professor Yi, and I now give the floor to Mr. Kirill Udovichenko. You have the floor, sir.
Madam President, members of the court, it is an honor for me to appear before you today on behalf of the Russian Federation. I will address Ukraine's new arguments on shelling, bombing, and killing incidents. In fact, what Ukraine has positioned as a solid case has now eroded to just a few isolated episodes in relation to which Ukraine still maintains its arguments. The Russian Federation, in turn, fully upholds its position and, as Madam President requested, would only respond to those arguments that have not been dealt with earlier. Let us now turn to what Ukraine says on shelling incidents. On Monday, Ukraine decided to retreat from discussing the human shield tactics of the Ukrainian armed forces. Instead, it shifted the focus by raising two allegedly fundamental points that Russia allegedly did not address. First point is whether the shelling incidents can undoubtedly be regarded as deliberate attacks on civilian population. And the second point is what we define as the context of these incidents. Let us proceed to the substance of this statement. Ukraine says that Russia ignores the context. However, it would be more accurate to say that Russia does not accept the context offered by Ukraine. This context is totally made up in order to meet the definition of terrorism, to allege that whoever performed the shelling had an intent to intimidate population or compel government. Ukraine failed to show that these incidents were aimed at intimidating the population or resulted in such intimidation. So Ukraine turns to the second limb of the definition. It wants the court to think that the context of shelling is formed by the Minsk negotiations. However, such assumption is unwarranted by anything other than Ukraine's desire to link unrelated events to one another. It remains unproven how the incidents could have impacted negotiations, as no evidence is provided that the shellings were discussed, considered, or in any way affected this process. Their real context, therefore, was a pending military conflict. The sad reality with which Ukraine undermines was that the civil strife in Ukraine and the military operation against the republics resulted in numerous civilian casualties. This is the context of the Minsk negotiations Ukraine wants you to see. This is the context that media reported. But there is also an even wider context visible to those engaged in the Minsk negotiations. As indicated by the International Committee of the Red Cross, and I quote, "In eastern Ukraine, along the line of contact from the beginning of the conflict in February 2014 and until mid-August 2019, the ICRC documented over 1,500 incidents in which heavy explosive weapons were used in populated areas," unquote. The overwhelming majority of these cases are attributed to Ukraine's forces, and each of the 1,500 incidents is a tragedy. However, there is no way of considering that some of them are more important or more indicative than the others. Now, briefly on the second fundamental point as advanced by Ukraine. If we ignore the fog of war that covers many aspects of these incidents, there is still no convincing reason for an independent observer to believe that the purpose of the shelling was to harm civilian population. First of all, neither in 2014 nor today it has been reliably established who was behind the shellings. Second, the attacks were aimed against military targets, and this requires no further justification in the context of an armed conflict. Now I address what is left of the specific objections of Ukraine. In Volnovakha, the shelling targeted a roadblock. Ukraine tries to convince the court that the roadblock was not a military target. Ukraine suggests that vehicles stationed at the roadblock were lightly armored and used by police. This is inaccurate. Two Russian experts characterize BRDM-2 as an armored fighting vehicle which is designed for reconnaissance and battle, or how the OSCE Special Monitoring Report identifies it, armored combat vehicle. The reports by the United Nations Security General also states that BRDM-2 is an armored combat vehicle. All definitions stress that this materiel is intended for waging battle, not policing. On the left slide, you can see a so-called Tiger. This Monday, Ukraine told us that the Russian parliament member, now deceased, Vladimir Zhirinovsky, supplied a similar vehicle to the LPR. Apparently, it is in fact used by the ordinary police. Nevertheless, Ukraine claims it a military vehicle. On the right is a photo of BRDM-2, a vehicle stationed in Volnovakha. If Ukraine argues that the Tiger is a military vehicle, then the BRDM-2 not only meets such tests, but goes far beyond. You can even spot the automatic grenade launcher mounted on top of it, something you would never see with a police force. An anti-tank grenade launcher and a heavy machine gun could be seen on the fighting position on top of the roadblock itself. Police are not expected to use those either. Ukraine also agrees that the Ukrainian armed forces' strong point near Berezhnoye is a military target. They consent to that. It invite us to compare it with the Volnovakha roadblock. Well, let's do it. You can see that all elements are identical. Stationed armored vehicles, trenches, firing holes, concrete blocks, dugout positions for firing vehicles, even a checkpoint. If it looks like a military site, if it is armed like a military site, if it operates like a military site, then it is ultimately a military site, and hence a valid target. Notably, as satellite imagery showed after the shelling of the roadblock, Ukraine did construct a separate civilian checkpoint near Berezhnoye, whereas Volnovakha roadblock continued to be used as a military installation. On Monday, Council for Ukraine stated that BM-21 should be used against the roadblock due to its size, should not be used against the roadblock due to its size. However, this is a misinterpretation of Russian military doctrine. A roadblock is a single target. In fact, in shooting theory, it is generally accepted that single turrets have no dimensions. Ukraine further suggests that the roadblock should have been attacked by cannon artillery guns rather than MLRS. At the same time, Ukrainian experts conclude that the shelling was done from the vicinity of the town of Dokuchayevsk, which is 19 kilometers away from the roadblock. This distance makes an attack by cannon artillery that is available to the republics simply impossible. As both Russian ballistic experts and General Brown state, a 122mm cannon artillery maximum range is approximately 15 kilometers. It drastically loses precision, though, if fired from more than 10. So it would most likely miss the target. Perhaps an attack with artillery guns might have been more precise, in principle. But there was no way republics could perform it. Even if artillery gunfire was an option, this precise gunfire would not have prevented the unfortunate destruction of the civil bus, as it has been positioned in the very center of a roadblock. Finally, Ukraine wraps up its arguments on Volnovakha roadblock by arguing that the attack intended to cause civilian death. Russia has already responded to that and explained that there was no reason to believe civilians were intentionally targeted. Nor did Ukraine disprove that the attack was carried out by Ukrainian forces, as the spoilerings on the missiles leave no other plausible options. I would only add up by referring you to the map presented by Ukraine. We can see that between the roadblock and the territory controlled by the DPR, there is a town of Buhas, with a reported 1,500 population. If indeed the republics intended to hurt civilians, an attack would be carried out against such target and not a standalone roadblock lost in the field with a narrow road nearby. Mariupol. Ukraine could not disprove the existence of military checkpoints nor the set of trenches between them. It only complained that the trenches themselves appear empty on the satellite image. Ukraine misrepresents the conclusions made by its own expert, who stated that imagery cannot determine whether these trenches are occupied. In any case, even if the trenches were indeed empty, that does not imply that they were not filled with personnel when the shelling occurred. The other obvious argument is that the photo was taken 2 weeks after the incident, and by that time, the military personnel from those trenches might have already relocated to the residential areas of Mariupol. This is exactly what was feared by the speaker presented on the slides by Ukraine. I quote, they, references made to the Ukrainian military, are forcing people to leave, that is, from the residential area, and they, the military, are going to sit there, unquote. On Monday, Council for Ukraine argued that the DPR members studied the coordinates of the fortifications outside of the Mariupol city. Remarkably, to support this point, Ukraine displayed on its slide number 33 an extract from the alleged intercept dated January 13, 2015, just several days before the shelling of Mariupol. Here, the alleged DPR military personnel discuss coordinates near Dokuchayevsk and Slavne. These towns are some 70 kilometers away from Mariupol. Clearly, this evidence, if evidence at all, is misplaced. Finally, one cannot indeed rule out that the coordinates supplied to the republics might have been inaccurate. A local observer, Mr. Kirsanov, who allegedly guided the artillery, later confessed that he intentionally provided wrong coordinates. It is believed that this person has been recruited by the Ukrainian military, as he later stated Ukraine, and escaped any serious punishment. Kramatorsk. OSCE has clearly established that the explosions at the airfield and impacts on the residential areas happened simultaneously, 12:30 p.m. Thus, the shelling of the city occurred at the same time as in course of the pending assault against the airfield. It would be impossible to simultaneously target some rockets at the residential area and the rest to the airfield. This would require retargeting and is inconsistent with the facts at hand. My final remark on shelling would be that it appears cynical that Ukraine calls the underlying shelling incidents repeated attacks, let alone they occurred in different places and ended relatively quickly. In contrast, let me show you what a repeated attack really looks like. I again take you to the DPR city of Donetsk. Human Rights Watch and other international organizations documented constant, repeated attacks from Ukraine, attacks lasting for several days, resulting in numerous casualties. This is a repeated attack, while what Ukraine presents is a tragic but a textbook example of collateral damage. Now I quickly turn to the issue of bombings. Ukraine argues the grand total of 2 incidents, labeling them as a terrorist bombing across Ukraine. Russia submits that the court cannot base its decision on coerced confessions that were confirmed, among other sources, by the OHCHR report. Ukraine attempts to disprove that the confessions were coerced and argues that it is a full body of evidence confirming Russia's involvement. Well, let us look into what this body consists of. It is made of the SBU reports, letters, expert opinions, and extracts from criminal cases, all being part of the same court file that led to the imprisonment of the people designated as perpetrators. That evidence is no better than confessions and gets Ukraine nowhere near proving its claims. This is because the sources and authors of those documents are again the same, the SBU and Ukrainians' law enforcement agencies. For example, the same SBU Kharkov department that, according to OHCHR, practice mock executions, asphyxiations, electrocution, and other kinds of physical and psychological violence on the so-called Kharkov partisan. These pieces of evidence have no face value. Russia's involvement in training Mr. Kovtun is deduced from, for example, the fact that she crossed the Russian-Ukrainian border. Well, this is not unusual. According to Ukraine's own evidence, Mr. Kovtun's mother lives in a nearby Russian city of Stavropol, and Ms. Kovtun visited her. This is very common for people from neighboring regions to visit each other. The assault rifles were found in the hideout. Later, SBU concluded that this hideout conveniently belongs to Ms. Kovtun. The discovery is only proven by the search and seizure report. No witness statement or attorney were present and called for this procedure. A clear violation of Ukrainian law committed to mask another mystification of the SBU. The note confirming another SMP mine has been found in Kharkov is literally just a text with no signature or validation marks. SBU allegedly extracted several hard drives from Ms. Kovtun, and some severely incriminating materials were allegedly found there. Where are those files? Why are they concealed from the court? Not a single sensible voice or video recording was produced. Most likely they do not exist at all. Ukraine only showed documents from SBU and other law enforcers. In essence, these are just SBU creative work, providing us with out-of-context extracts attributed to some video or records. Clearly, such a low standard of proof is in no way appropriate for the court. I can go on dismantling each argument that Ukraine considers evidence, but there is clearly no link to the so-called Kharkov partisans to Russia or the republics. Otherwise, Ukraine would have your eyes all over the respective piece of evidence. In contrast, in the absence of such evidence, they now invite you to trust the SBU, to believe in the Russian plot narrative. However, a Russian plot is no more than a speculative concept used to manipulate public. We have all seen how this plays out in politics or media. This highlights the importance of verification, especially when secondary material comes exclusively from one side, a state agency of the disputing party. Take a look at the slide shown by Ukraine on the MH17 matter. There, the Dutch prosecutor and the Hague District Court at least asserted that they needed to exercise special care in this respect. Perhaps, as SBU word cannot be trusted. The court expressly noted that because a significant part of this evidence was initially obtained from the SBU, the court conducted additional checks to establish the reliability, authenticity, completeness, and veracity of such evidence. If the court makes use of the evidence introduced via the SBU, it will do so with due caution, in accordance with applicable provisions. We say the court should take a demanding approach here. Ukraine was already being caught red-handed on using coerced confessions. The court cannot extend SBU any indulgence and rely on its biased, one-sided reports. This would strike a terrible precedent, allowing states to produce masses of credible but totally made-up evidence. Without any primary evidence, Ukraine's claims on bombing and killing incidents and the Russian trace in all of them is just a combination of politically motivated accusations without any evidence to properly back them up. There is no place for such claim in any court of law. This respectfully concludes my submissions. I kindly request that you invite Professor Sianholi.
I thank Professor Udovichenko, and I now invite Professor Sianhuli to address the court. You have the floor, Professor.
Madam President, members and judges of the court, I now come to Ukraine's case on cooperation. There are three problems with what Counsel for Ukraine told you on Monday. One, there were false statements which I will correct. Two, there were empty statements which I will show are not backed up by any evidence. And three, there were critical arguments made by Russia that Counsel for Ukraine simply ignored, naturally for good reasons. First, I come to standard of proof. Let me remind you, and I believe Counsel for Ukraine did not tell you this on purpose. The court does not need to look at Russia's cooperation obligations unless and until Ukraine conclusively proves all elements of a terrorism financing offense. Only if the court rejects Russia's case on intent, funds, MH17, shelling, and bombing, only then will you need to consider how well Russia cooperated with Ukraine. Here, Ukraine is wrong in asserting that the test of fully conclusive evidence applies only in cases of genocide. Counsel for Ukraine dare not show you the relevant quote from the Bosnian genocide judgment because the court simply did not say so. The court gave a general principle, and I quote, "The court has long recognized that claims against a state involving charges of exceptional gravity must be proved by evidence that is fully conclusive." End of quote. Charges like genocide, but not just genocide, requires such evidence. Counsel for Ukraine also did not say that the court cited another case, Korfu Channel. Now, that case had nothing to do with genocide. It was about explosions of sea mines that damaged some warships. And there, the court also applied the standard of conclusive proof. Why are there these two tests? A higher one for the court and a lower one for the competent bodies of states? Because competent bodies of states operate when the situation is ongoing and things may not be clear yet. But when a case reaches this court, the dust has already settled, and Ukraine cannot hide behind what may have been sufficient for competent authorities to identify in the past. Instead, Ukraine must offer conclusive evidence to back up its serious claim that Russia failed to prevent terrorism financing, or else the court should dismiss that claim. Article 8 to 10. Now, Ukraine continues to mislead the court about standards of proof when it comes to specific obligations. For example, the asset freeze obligation under Article 8. Last Thursday, I said that Russia uses the test of sufficient ground to suspect to freeze one's assets, which is stricter than a test of reasonable suspicion because it requires reliable, credible evidence in support of a freezing request. On Monday, counsel for Ukraine said that I was wrong and that the FATF report identified by Judge Note says that Russia applies the reasonable suspicion test. But counsel conveniently skipped the slide with the relevant quote from that report. And I want you to see it. It plainly says sufficient ground to suspect, not reasonable suspicion. Another false statement by Ukraine that I have to correct. Now, on fact, counsel for Ukraine said Ukraine always cooperated in good faith, answered Russia's requests for further information and provided with evidence. But that is with respect. Another empty statement that counsel for Ukraine does not back up with any evidence. Let's take a look at some examples. On October 14, 2014, Russia asked for Ukraine for further information. Please provide the Russian side with factual data on the issues. And please hand over to the Russian Federation the criminal cases brought by Ukrainian law enforcement authorities against Russian citizens. But where can the court find Ukraine's response to this request? Counsel for Ukraine did not show it to us. And indeed, there isn't one on the record. On July 31st, 2015, Russia sent another request. No answer. On October 23rd, 2015, Russia sent another request. No response again. Let me be clear. Ukraine never, not once, not as Ukraine's counsel said, 6 times responded to Russia's requests. Worse yet, Ukraine itself does not follow the rules it wants to impose on Russia. As noted earlier, when Russia asked Ukraine for extradition of members of an organization which Russia considered to be terrorist, Ukraine refused, just because this organization was not recognized as terrorist by Ukraine. On Article 12, and this is the core flaw in Ukraine's case on cooperation in general, and on Article 12 in particular. That is the flaw that not just Russia, but other countries complain about Ukraine. The FATF report on Ukraine, which you have already seen today, says, based on meetings with authorities and as already substantiated by open sources, the evaluators have been made aware of cases in which Ukraine had not been effective with regard to outgoing MLA requests by failing to provide requested countries with sufficient evidence in a timely manner. Madam President, members and judges of the court, it takes 2 to tango, as we say. Likewise, in international law, it takes 2 honest states to cooperate on mutual legal assistance. Ukraine cannot simply mail out multiple requests to Russia but not back them up with proper details or evidence and then complain Russia did not execute them. Just look at the quality of Ukraine's letters. 1. Ukraine writes, Ukrainian side has evidence that unidentified individuals, by unlawful means, directly or indirectly, intentionally moved military equipment from the territory of the Russian Federation to the territory of Ukraine. No competent body of any state will be able to act on this information. Or, as Ukraine said, Ukraine fails to, or another instance, Ukraine fails to provide necessary data. The request for legal assistance does not indicate first names and surnames of witnesses, their official and actual places of residence, and their places of birth. These are not just procedural formalities. Such details are paramount. No competent body can process an MLA request without properly identifying another person or a person of interest, or else there will be mistakes. For example, Ukraine complains that Russia was unable to locate an individual named Mr. Yukovsky with one letter K, even though he had a social media page. But on that page, his name was different. It's Mr. Jushkovsky with 3 letters, CHK. Last Tuesday, Counsel for Ukraine again called this individual as Mr. Jukovsky without 2 letters, CH. So, if not even Ukraine's legal team can determine what is the real name of that person of interest after working on the case for 6 or 7 long years, then with respect, Ukraine cannot criticize Russia's response that that person with that name does not exist. Then on Monday, Ukraine tried to challenge my numbers of how many MLA requests Russia has received and executed them from 2014 to 2020. But it is their statistics that are flawed. The same FATF report on Ukraine says, with regard to MLA, statistics are maintained by not 1 but 3 agencies: the Anti-Corruption Bureau, the Prosecutor's Office, and the Ministry of Justice on requests made and received. The MLA statistics for 2013 and 2014 have been destroyed, meaning that the available statistics are not comprehensive. With regard to other international requests for cooperation, various agencies maintain statistics on requests made and received, while the Prosecutor's Office and the Anti-Corruption Bureau do not have a system and statistics are not maintained. End of quote. Counsel for Ukraine cited Ukraine's Prosecutor's Office as her source, but the court now knows that from this report, there are at least 2 other agencies dealing with MLA requests. No central system between them. And the Prosecutor's Office destroyed at least some of the data on those requests. So what Counsel for Ukraine told you about some 91 requests and 58 rejections is patently incomplete and misleading. It shows Ukraine's bad faith. Ukraine never mentioned before this number of 91 requests on terrorism financing and refused to provide Russia with a list of its MLA requests related to the convention during the consultations between the parties before the case came to this court. Nor has Ukraine provided these requests to the court. On Tuesday last week, Ukraine's own lawyers only referred to 12 MLA requests, not 91. Now, I would like to highlight a few critical arguments on cooperation that Russia made in this case, but Ukraine simply left without any answer. 1. Why did Ukraine use diplomatic correspondence to request assistance from Russia? No one does that because it is the slowest possible channel, especially when, if I may borrow Counsel for Ukraine's words, speed is essential. No wonder Ukraine waited for a year to get a response. If Ukraine used the standard MLA channel, it would have received a response in no more than months. 2. Why did Ukraine ask Russia to freeze assets in Ukrainian banks? No state relishes giving another state jurisdiction to do that on its own territory. 3. Why none of MLA requests Ukraine used to build its case here refer to terrorism financing or ICSFT? They all concern other offenses. 4. Why does Ukraine criticize Russia for referring to Article 19 of the Minsk Convention and the ground of prejudice to national sovereignty or security, when Ukraine itself uses that ground to reject Russia's requests without any explanation. You can see multiple examples of Ukraine's own practice on the slide. Ukraine did not say anything on this, not because it did not have time or they were not important, but because it has no good answers. Let's take as an example, the MLA requested Ukraine spotlighted on Monday the request about Mr. Urinovsky. He's now deceased, but in 2014, he was a deputy speaker of the Russian parliament, a very important politician. The request accused him of gifting a military vehicle to LPR, but in reality, as my colleague already explained, it was not a military vehicle. The request also did not refer to ICSFT, terrorism financing, or provide any evidence that LPR was a terrorist organization. Of course, the request was rejected on grounds of sovereignty, but was groundless in any event. Overall, Ukraine's letters to Russia, much like Ukraine's oral argument on Monday, may have been replete with legalese and high-flown political accusations, but they were equally devoid of any detail or supporting evidence. There is no place for such an approach in a court of law, definitely not in this august institution or in any mutual legal assistance correspondence. As it will be shown by my colleague, the FATF report confirmed that Russia performed its obligations in a constructive and timely manner. Now I come to Article 18. Here, counsel for Ukraine refer en passant to the Aegean Sea case and made a blunt remark that this case supports Ukraine's reading of the word notamment. But counsel for Ukraine never actually took you to that case. If she did, you will see that the court interpreted a different phrase, et notamment, which has a different meaning, and in particular, or something in addition to what has been listed. In fact, that case supports Russia's argument. First, according to the court, I quote, the word et is intended to be a true conjunctive, introducing a category of différents, additional to those already specified, end of quote. And the word et is not in Article 18.1 of the ICSFT. Moreover, in that case, the court gave particular emphasis to context, and that approach has been what Russia insists on. As I argued last Thursday, context is on our side, and Article 18.2 makes it sufficiently clear that all practical measures in Article 18.1 cannot be a catch-all phrase. Counsel for Ukraine argues that our reading of Article 18.1 as encompassing only regulatory measures makes this article a nullity. But may I say that, to the contrary, it is counsel for Ukraine's interpretation of Article 18.1 as a grand catch-all provision that will render a nullity Article 18.2, as I pointed out last Thursday, the rest of Article 18, and then all the other provisions of the whole Convention relating to cooperation and prevention. But the drafters of the Convention were careful to produce a detailed and comprehensive instrument. So converting Article 18.1 into a catch-all provision would simply eradicate these efforts. Ukraine's argument on Article 18 ultimately boils down to a baseless complaint that Russia should have instructed its state officials not to finance terrorism in Ukraine. I do not know in what format Ukraine wants that instruction to be, but for avoidance of any doubt, my colleagues inform me that Russia always instructed its officials not to finance terrorism in any jurisdiction, not just Ukraine, and it is Russia's position that they never did. Madam President, members and judges of the court, this concludes my argument on cooperation. Madam President, may I invite you to give the podium to Mr. Kosarukov to continue Russia's presentation. Thank you.
I thank Professor Yee, and before I invite the next speaker to take the floor, the court will observe a coffee break of 10 minutes. Sitting is suspended. Please be seated. The sitting is resumed, and I now invite Mr. Kosorokov to address the court. You have the floor, sir.
Madam President, distinguished members of the court, it is an honor to appear before you today with Russia's response to the question posed by Judge Knopp regarding the FATF evaluation of Russia. The question should now be on your screens. The purpose of foreign evaluation is for the Financial Action Task Force to assess how effectively each country is fighting money laundering and terrorism financing. Its assessment is based on FATF recommendation number 5, which goes beyond the ICSFT in some respects. See slide 3. Recommendation number 5 contains elements which deliberately go beyond the various international legal obligations. Note also at slide 4 Russia's rejoinder at paragraph 211. It should be noted that the Security Council resolutions, the guidance on their implementation, and relevant FATF recommendations may extend beyond obligations enshrined in the ICSFT. For example, as noted in the technical guide to the implementation of Security Council Resolution 1373, Recommendation 5 of FATF and its interpretive note go beyond the obligations contained in the ICSFT in requiring states to also criminalize the financing of terrorist organizations and individual terrorists on a broader basis without requiring a link to a specific terrorist act or acts. It follows that the evaluation is helpful in some ways, for example, on Russia's degree on cooperation. It is less relevant in others. It does not help on interpretation of the ICSFT offences, since it is based on a recommendation that goes beyond the Convention. Slide 5. Overall, you may have seen that Russia's performance is very good. Out of 62 available reports for member jurisdictions of FATF, Moneyval, and EAG, only 5 countries, including Russia, achieved high level of effectiveness on investigation and prosecution for terrorism financing. Regarding mutual legal assistance, FATF says that Russia acts in a constructive and timely manner, responding to nearly 6,000 requests per year, and rarely refuses to execute MLA requests. See slide 6 and the recommendation at slide 7 that Russia should continue to provide constructive cooperation to all partners sending valid requests. Ukraine suggested on Monday that Russia had somehow concealed from FATF its alleged violations in respect of Ukraine. I quote, Russia's failure to tell the FATF anything about its non-existent efforts to address terrorism financing in Ukraine does not exonerate Russia, it condemns Russia. That, with respect, is simply wrong. Slide 8. Part of that evaluation was feedback from other states, which expressly included Ukraine. See, in total, 34 jurisdictions provided feedback on their formal and informal international cooperation experience with Russia in recent years. And right there on the list, you can see Ukraine, near the bottom. Slide 9. Ukraine apparently did complain to FATF about Russia's cooperation concerning DPR and LPR, and the FATF dismissed it as pertaining to a political dispute. Here I quote, these cases relate to an ongoing political dispute, cooperation on matters outside the political dispute, appears to be proceeding smoothly. Overall, the feedback on MLA trended positive, with some outlying complaints. It follows that FATF did not accept Ukraine's characterization of the DPR and LPR as terrorist organizations, nor was it aware of their notoriety as such. Otherwise, there would surely have been adverse comment. With regard to extradition, FATF concluded that Russia will prosecute individuals when it refuses extradition on the grounds of nationality. However, the likelihood of prosecution often depends on whether the foreign authority provides evidence sufficient for Russia to open an investigation and bring its own charges. In the view of FATF, Russia is generally keeping up with the volume of requests in this busy area of cooperation. Here we should recall that Ukraine did not supply sufficient evidence and refused to provide Russia with its criminal case files so that Russia may conduct proceedings. By contrast, Ukraine's own performance was poor. Slide 10. For example, Moneyval says that in Ukraine, the effectiveness of incoming MLA, in particular in relation to asset seizure and confiscation, remains hindered by factors such as corruption and breaches of confidentiality, weaknesses in the domestic regime for the seizure of documents, and the absence of a prioritization system for processing requests. Slide 11. Then Moneyval goes on that the majority of requests for assistance were denied by Ukraine on the grounds that they were of a political nature. Slide 12. More importantly, Moneyval looked at Ukraine's outgoing requests for assistance, whether addressed to Russia or to other countries, and identified a key problem with them. Here I quote, "Based on meetings with the authorities and also as substantiated by open sources, the evaluators have been made aware of cases in which Ukraine had not been effective with regard to outgoing MLA requests by failing to provide requested countries with sufficient evidence in a timely manner." So other countries have had problems with non-compliant and political requests by Ukraine, along with Russia. On funds, there is some additional relevance. The FATF report never once refers to weapons as covered by funds, only as something that can be procured for funds. Slide 13. Ultimately, FATF concludes that Russia's competent authorities should continue to provide constructive cooperation to all partners sending valid requests. This indicates that FATF did not object against Russia not executing non-valid requests that another country, Ukraine, was improperly exploiting in a political dispute. Since the FATF report has been adopted in 2019 and never mentioned any violation in the field of combating terrorism financing, despite receiving feedback from Ukraine, it can be assumed that this independent international body did not find whatever Ukraine complained about to be contrary to Russia's international obligations under ICSFT. This concludes Russia's response to Judge Nolt's question. Madam President, I would like to ask the Court to invite Monsieur Jean-Charles Chikaya to present Russia's position on said. Thank you for your attention.
I thank Mr. Kasarukov, and I now give the floor to Professor Chikaya. You have the floor, Professor.
Merci, Madame la
Thank you, Madam President. Madam President, distinguished members of the Court, it is a great honour for me to appear before you once again on behalf of the Russian Federation. Today, it is for me to answer our opponents as regards the object of the dispute and the definition of racial discrimination under the CERD. Having heard Professor Coe on Monday refer to the arrest warrant issued against President Putin, wondering about how many rubles, and I quote, the latter spent in order to destroy Mariupol and Bakhmut, or, and I quote again, to brutalize the inhabitants of Bucha, Irpin, and Izium, and then to state, and he was the only one so far to know this, I quote, that international law and this court are toothless. So having heard that, it is the duty for me now to clarify the object of this dispute before the court as defined in the 2019 ruling on the preliminary objections. In order to comply scrupulously with your instructions, Madam President, as regards this phase of the oral proceedings, I shall not repeat myself, but I would like to focus on certain important aspects. As recalled during my previous presentation, the object of this dispute, which is extremely serious, is limited both ratione materiae and ratione temporis. In reality, it is for the court to decide whether Russia carried out a systematic campaign of racial discrimination in breach of its obligations under CERD against the Crimean, Tatar and Ukrainian communities, and this according to the application instituting proceedings of February and March 2014 to December 2016. For Ukraine, this alleged behavior is seen as a systematic violation of an imperative norm of international law, jus cogens. On Monday, one of our opponents accused Russia of having mischaracterized the application by Ukraine. According to it, Ukraine describes a multitude of discriminatory acts on the part of the Russian authorities, the purpose or effect of which is to destroy or compromise the human rights of Crimean Tatars and Ukrainians. According to Ukraine, Russia allegedly targeted these communities as a form of collective punishment for their alleged opposition to the reunification of Crimea with Russia. But what is it that Russia has mischaracterized? What was described by Ukraine on Monday is precisely the aspect of the dispute on the systematic campaign of racial discrimination that we went into. And this was done during the first round of the oral arguments. It's also the way in which the court defined the dispute in its 2019 judgment, as I have just recalled. Ukraine's claims relate to an alleged pattern of conduct of the Russian Federation. Ukraine is asking that an end be brought to the systematic campaign of racial discrimination. There's no need to recall what goes without saying here. Ukraine, in its written submissions, has always accused Russia of having carried out a systematic campaign of racial discrimination, of seeking to erase the Crimean, Tatar and Ukrainian communities. It has made numerous accusations, as the court will have noted. On Monday, one of the counsel for Ukraine, without any hesitation nor any evidence to rely on, referred to tens of thousands of Tatars and Ukrainians who allegedly were subject to the consequences of this so-called campaign of racial discrimination. I note that Ukraine finally acknowledged that the fundamental question was to see whether Russia carried out a systematic campaign of racial discrimination. So it is perfectly legitimate to ask, why is Ukraine reluctant to speak of a systematic campaign of racial discrimination, thus deviating from its initial request? As we see it, the answer is fairly straightforward. Having circumvented the preliminary objections of Russia by formulating its application in extremely grave terms, Ukraine realized that it had made a massive error, because in so doing, it came up against a major difficulty, that of evidence for the alleged facts and its application in its entirety. And in order to overcome that obstacle, it tries to broaden the scope of the convention and get off with just a few allegations of racial discrimination. Madam President, I think that I have demonstrated the criteria that have to be met by Ukraine in order to prove the existence of any systematic campaign of racial discrimination. Very briefly, let me run through the criteria. The alleged acts have, of course, to be attributable to the Russian Federation. The alleged acts have each to constitute a violation of the Convention, in other words, a distinction, exclusion, restriction or preference based on race or ethnic origin within the meaning of the Convention, which has the purpose or effect of nullifying or impairing the recognition, enjoyment or exercise on an equal footing of human rights and fundamental freedoms. and which has no objective nor reasonable justification. Thirdly, the alleged acts have to be part of a systematic campaign or policy. I've also added that there are certain specific conditions that have to be met for the alleged conduct by Russia to be considered as a systematic campaign. We note that Ukraine has not challenged this, but according to Ukraine, it would be possible mechanically to accumulate the unfounded allegations in support of its application, which, to my mind, is untenable. What is more, Ukraine continues to assert that it has no obligation to prove discriminatory intent on the part of Russia. Aside from the question of seeing or finding out how a state could carry out a systematic campaign of racial discrimination unwittingly, for which it would be so difficult to prove the existence of such an intent if, according to Ukraine, and I quote them, there were to be tens of thousands of victims of any such alleged systematic campaign. And Russia would allegedly have targeted the Tatar and Ukrainian communities. Citing these sort of allegations with nothing more than that, does that make it necessarily a systematic campaign? This brings me now to my point concerning the required standard of proof. Ukraine's accusation is exceptionally grave, comparable, as I said the other day, to acts of Nazi Germany or the apartheid regime in South Africa. We note that Counsel for Ukraine has made no observation on that point. In view of the exceptional gravity, our opponent's accusation has to be proved, according to your jurisprudence, and I quote, by conclusive evidence. Ukraine is trying to persuade you that a standard of proof to be applied should be different in the case of Russia. It refers, as regards Russia, to a standard of proof that's duly established or sufficient evidence or conclusive evidence. It also refers to the Corfu Channel case and says that it should be allowed to have more liberal recourse to inferences of fact and circumstantial evidence. And in so doing, it bases itself on an alleged absence of access to Crimea. Ukraine insists on this point, and that confirms that it has not met its obligations in terms of evidence, nor does it quote the judgment of the court as it should have done, because it's been ruled that indirect evidence is particularly compelling when it's based on a series of facts which logically lead to the same conclusion. Obviously, even circumstantial evidence requires a very high standard of proof, always. Far from Ukraine to have demonstrated the existence of a systematic campaign of racial discrimination, maybe even on the basis of this standard. What is more, the argument according to which Ukraine allegedly has no access to Crimea is irrelevant in this instance because the statistical data is publicly available. Ukraine, however, chooses to overlook this. It should be underlined that the court has indicated in similar circumstances that, and I quote, in respect of the applicant's claim that the respondent has breached its undertakings to prevent genocide and to punish and extradite persons charged with genocide, the court requires proof at a high level of certainty appropriate to the seriousness of the allegation. End of quotation. It is worth recalling here as well that this question, on this question in Croatia versus Serbia, the court considered the possibility of acknowledging indirect proof of an intention to commit genocide by way of deduction. It necessarily requires that such a conclusion is the only one that could be deduced from the acts at issue. A final observation concerning the administration is necessary. As we noted last Thursday, Ukraine seems to attach considerable weight to certain reports by the United Nations High Commissioner for Human Rights. However, information concerning Crimea that have been produced by the High Commissariat are almost exclusively, and I underscore this, almost exclusively based on data provided by NGOs that are sponsored by the United States and certain European governments. These reports in themselves, therefore, cannot be used as sufficient evidence, and certainly not conclusive evidence, in order to establish Ukraine's allegations. This brings me to the importance of statistical data. As regards the question of the importance of statistical data, Ukraine states that statistical data is not necessary in all cases of allegations of racial discrimination. Russia has already demonstrated that this approach is erroneous, nor is it reasonable, particularly in this particular case, in other words, in an alleged case of systematic campaigns of racial discrimination. In any case, statistical data is in the file. Russia has produced ample statistics, but Ukraine is asking quite simply to overlook them and follow, according to it, a certain common sense approach. Of course, it goes without saying that there is no sense to be attached to this. According to common sense, if statistical data is used, it should be used in order to avoid there being any speculation. If Russia were really carrying out a systematic campaign of racial discrimination, this would necessarily be proved by the statistical data, but that is not the case here. The statistics provided by Russia show, once again, that there was no abnormal situation in Crimea as compared to what you see in other regions of Russia. If Ukraine's accusation were to be plausible, the facts and figures, for example, concerning disappearances of individuals and extremist offences would be far higher. Without statistical data and without any discriminatory legislation in Russia, we cannot see on what basis Ukraine contends that entire communities are allegedly being targeted by the Russian government in order to erase them, and that allegedly there's some state plan or policy in this regard. By denying the importance of making any comparison in order to come up with proof of a differentiated treatment, Ukraine is insinuating that any measure directed at an individual of a given ethnic origin would ipso facto be racial discrimination. But that is quite clearly untenable. Demonstrating a different treatment of an individual, or in this case of a particular community, comparing it with another, on the basis of grounds banned under CERD, is essential if we're to prove that there's been any racial discrimination. Such differentiated treatment does not exist in Russia as regards the Tatar and Ukrainian communities. Madam President, members of the court, as you heard on Monday, Ukraine argues furthermore that Russia misinterprets CERD, particularly as regards the notion of discrimination by effect and the supposed indirect discrimination. Ukraine's arguments must be dismissed for several reasons. First of all, I have to clarify that, contrary to what our opponents have argued, Russia in no way denies that racial discrimination by effect would be a violation, a breach of the Convention. But it should be recalled that here, this is not the request that was acknowledged in your ruling of 2019, and that all relevant elements are to be found in Article 1, Paragraph 1 of CERD, even if Ukraine is attempting to give a partial interpretation thereof. You see the paragraph of this article on your screen. Russia's interpretation of what makes up racial discrimination fully complies with all of these conditions. Ukraine's position presents a major drawback. It seeks to eliminate differentiated treatment, which is a fundamental element of the definition of racial discrimination. It attempts to eliminate it from the text of the treaty. In other words, for Ukraine, there may be racial discrimination even if there's no distinction, exclusion, restriction or preference establishing a hierarchy between social groups. This attempt to rewrite Article 1, we have understood, is necessary if Ukraine's arguments, if one of Ukraine's arguments is to succeed, in other words, that of indirect discrimination. According to our opponents, indirect discrimination is included under the term discrimination by effect. On Monday, one of the Council for Ukraine described the so-called indirect discrimination in the following way, where a facially neutral measure gives rise to an unjustifiable disparate impact along racial or ethnic lines, Ukraine is basing this primarily on the Fredman report. This notion of indirect discrimination is in no way compatible with the definition of racial discrimination that I have just explained to you. The third requires a distinction, exclusion, restriction, or preference. Without this different treatment on the basis of race or ethnic origin, there is quite simply no racial discrimination within the meaning of the Convention. Recommendation 14 of the Third Committee clearly confirmed this, and I quote, when it noted that different treatment is not an act of discrimination if, compared to the object and purpose of the Convention, the differentiation criteria are legitimate.
Ukraine, however, considers that different treatment could be and lead to an unjustifiable disproportionate effect. Now, this has never been explained, or its meaning has never been explained in our opponent's pleading. When can you say that an effect is disproportionate or unjustifiable? How can this fit in with the need to show that there would be distinction, exclusion, and restriction or preference, which would have as its purpose or effect to destroy or limit the human rights of one social group compared to another? In fact, Ukraine is not referring to some kind of disproportionate impact, but to equal result, which is in fact not foreseen by the Convention. To support this, Ukraine also relies on the opinion of Professor Friedman, according to whom the indirect discrimination or disparate impact focuses on inequality of result rather than inequality of treatment. But this, I'm sure you will recognize, is not known to the Convention. Russia has shown quite clearly and convincingly that differentiated treatment is the sine qua non to establish any discrimination, racial discrimination. In fact, the Convention expressly requires it. The Third Committee in Recommendation 14 clearly states it too. The Court has also confirmed that indirect discrimination as defined by Ukraine, does not come into the scope of the Convention. In its 2021 ruling in the Qatar versus UAE case, the court ruled that while the measures based on current Qatari nationality may have collateral or secondary effects on persons born in Qatar or of Qatari parents, or on family members of Qatari citizens residing in the UAE, this does not constitute racial discrimination within the meaning of the Convention. In the Court's view, the various measures of which Qatar complains do not, either by their purpose or by their effect, give rise to racial discriminations against Qataris as a distinct social group. There is no reason why the court should diverge from its established case law. The measures taken by the Russian authorities, taken, for instance, on the basis of illegal extreme acts committed by some individuals, may, of course, lead to collateral or secondary effects on persons of Tatar or Ukrainian descent. In fact, on people of any racial or ethnic descent. But that does not constitute racial discrimination under CERD. This does not give rise either to in their purpose or their effect to racial discrimination against Tatar or Ukrainian communities on the basis of their ethnic origin. Ukraine also refers to the consultative opinion on minority schools in Albania. To convince you that this opinion on inequality, in fact, is analogous to the reference in CERD of the disparate effect of an apparently equal treatment. But that is not the case. In fact, the consultative opinion clearly shows that equality does not concern non-discrimination, but in fact a balance or equilibrium, notions which are not covered by the Convention. In matters law, you can say here, equality in law precludes discrimination of any kind, whereas equality, in fact, may involve the necessity of different treatment in order to attain a result which establishes an equilibrium between different situations. As concerns, Madam President, of now the supposedly discriminatory acts, what you need to understand is that Ukraine is no longer denying the obvious. at least as concerns discrimination by effect, including indirect discrimination, the acts of a state may well be justified and thus would not constitute racial discrimination under the Convention. In fact, Ukraine now states, in contradiction with its initial claim of an alleged systematic campaign of racial discrimination, it claims that its allegations rely on an alleged discrimination by effect, meaning that the measures taken by the Russian authorities may therefore be justified and be compatible with a convention. Now, it's also worth noting a significant particularity in the strategy of Ukraine. Even though it admits, as concerns discrimination by effect, that justification may be possible. At the same time, Ukraine states that the purpose to discriminate may be derived by inference only of the disproportionate effects of a measure. Now, with this argument, Ukraine seems to want to deprive states, or Russia in this case, of the opportunity to justify its objective conduct. And this would include carry a number of significant risks insofar as a measure taken by a state with the slightest effect on a minority or a single member of a minority in any field whatsoever should be considered as discriminatory and therefore in breach of the Convention. States would therefore be unable to take any necessary measures to ensure law and order or guarantee national security, lest it breach the Convention. And this absurd argument cannot be upheld by your jurisdiction. How can a state justify a measure? Let me refer you back to recommendation 14 of the committee. As you can see it up on the screen, I won't read it out entirely. It is very well known. Let me just, however, make a few comments in this respect. First of all, Ukraine has on a number of occasions accused Russia of wanting to consider the validity of its measures as being self-judging. Now, this is inaccurate. Every measure taken by the bodies of the Russian Federation come under the scrutiny of the Russian legal system, including the judiciary. Moreover, it should be noted that Russia has submitted to the jurisdiction of your court. Russia has absolutely nothing to hide. Secondly, one of the counsels for Ukraine also mentioned the tests that should be applied by the court to determine whether measures taken by the Russian authorities are justified. He noted that the committee gave no guidelines and that maybe we could refer to and rely on the opinions of the Human Rights Committee. Now, as concerns the committee, its practice shows that its justification for all sorts of very varied measure rely on various items. For instance, look at employment-related discrimination, which is one of the main body of opinions covered. In this context, issues relating to skills and competences of applicants may be seen to be discriminatory in an initial phase. Now, as concerns the Committee on Human Rights, Ukraine refers to observations number 27 and 37, focusing on the right of freedom of movement and the right to peaceful assembly. These do not deal with justifications in terms of racial discrimination. These observations, however, explain that exercising such right may be restricted to protect national security, law and order, public health, public morality, and the rights and freedoms of others. These restrictions must, in fact, be set forth in the law and must be necessary in a democratic society to protect the stated goals and must be compatible with all the other rights recognized in the covenant. Legal practice, as adopted by Russia, is entirely compatible with the rules covered in various multinational instruments. These instruments recognize rights such as freedom of expression, freedom of conscience, of religion, of opinion, and at the same time they consider the possibility of imposing legitimate restrictions as set forth in law. It is clear and obvious that the states parties to the convention could never have decided any other way, as Ukraine also recognizes. Now, the fight against extremism and terrorism is a crucial priority for Russia, as is the case for many other countries. Law and order related actions in this respect are absolutely not exceptions to the absolute prohibition of racial discrimination. These measures apply to anyone suspected of extremist activities. Race or ethnicity plays no role in this. Russian legislation itself considers that some aggravating circumstances in these instances would be racial, ethnic, political, ideological or religious motivations. Whatever the criterion applicable, the measures taken by the Russian authorities are justified in this instance. Russia has given reasonable and objective explanations for each of the measures at hand. Ukraine, on its part, has only banded vague accusations against the legal system in Russia and its anti-extremist legislation. Ukraine, as the applicant, has to prove that each of the measures taken by Russia is not justifiable under CERD. It has not done so, and years of proceedings have now shown that Ukraine cannot do so. As concerns the fight against extremism, and councils for Ukraine discussed this on Monday. Let me make a few brief comments. Professor Hadi Azari will revisit this issue in a moment. Ukraine is asking your court to consider that Russian laws are being applied abusively with the sole purpose of targeting Tatar and Ukrainian communities in Crimea. But there again, Ukraine has not proved anything. Our opponents want you to speculate, to consider that the Russian legislation is necessarily suspect, that you should draw a conclusion, a general conclusion for the entire body of law. And for Ukraine's allegation to hold, Ukraine would had to show that on an individual basis, the Russian law had indeed been abusively applied and created specific harm to the Tatar and Ukrainian communities. In its rejoinder and through the work of experts, Russia has shown that its anti-extremist legislation was adopted well before the reunification of Crimea with Russia. To support its accusations, Ukraine relies on an improper interpretation of the 2012 opinion of the Venice Convention and other statements made by the CERD committee. As Mr. Engel has shown, the Venice Commission nowhere states in its report that the Russian legislation is discriminatory towards racial or ethnic minorities. On the contrary, the Commission has recognized the legitimate efforts of the Russian authorities to fight against extremism and related threats. The Venice Commission has indeed, in other places, mentioned its concern as concerns the challenges related to the fight against extremism, including in its most recent forms. Mr. Engel has also stressed that the Venice Commission refers to the Shanghai Convention on Combating Terrorism, Separatism and Extremism, but it does not consider the 2017 Shanghai Organization's Convention for the Cooperation in the Fight Against Extremism. Lastly, as concerns the CERD Committee, Professor Avtonomov has explained that the committee describes the legal definition of extremist activities in broad and imprecise terms, but he has never suggested that the anti-extremist legislation in Russia should be repealed. What is important is that the committee has never determined that the Russian legislation would be discriminatory against Tatar and Ukrainian communities. Let us note that according to the statistical data, the extremist activities are not significant in Crimea. Over 2014-2022, the number of extremist offences in Crimea was 1.5% of the overall infractions and offences in Russia. Only 161 offences have been registered over 9 years, compared to 10,640 for the whole of Russia. 100 individuals have been prosecuted for extremist offences in Crimea, 1.3% of the total number of people people detained over 2014-2022, or 0.005% of the entire population of the region. Let me lastly mention the real aim of Ukraine in this case. And clearly, as you have heard over the course of the hearings, its aim is undoubtedly to discuss before your court of the status of Crimea, an issue that does not come under your jurisdiction. This is highlighted by two things. First of all, Ukraine is still insisting on the fact that political opinion would be relevant to establish ethnicity. As we have shown last week, this is entirely incompatible with your ruling in the Qatar against UAE. Indeed, the court observed that the definition of racial discrimination in the Convention includes national or ethnic origin. These references to origin denote, respectively, a person's bond to a national or ethnic group at birth. There's therefore no doubt ethnicity is a trait acquired at birth. All the efforts made by Ukraine to convince you to drop your case law is in vain. The political aim of Ukraine also transpires in the wording used. For instance, a collective punishment for their principled opposition to Russia's perpetrated annexation of Crimea, or a policy on Russia's part of neutralizing those voices capable of providing the Crimean Tatar and Ukrainian communities with political and intellectual leadership. Or those acts should be treated as discriminatory measures designed to force the ethnic groups into submission to Russian occupiers, not crimes committed against individuals for political reasons. So, as Russia has shown, the aim of Ukraine is indeed to discuss the status of Crimea. Let me just say that the ruling on the merits that the court will render in this case will apply and cover only the legal dispute that has been submitted, not political considerations. I can say that not one of the 182 states parties to the convention would ever agree to this very use, very remote from the object and purpose of the convention that Ukraine has attempted to put it to. The simple reason being that it would be Ukraine's will. Madam President, members of the court, I have come to the end of this presentation. Can I ask you to kindly give the floor to Professor Hadi Azari?
I thank Professor Shikaya, and I now give the floor to Professor Hadi Azari. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam President. Madam President, I shall now turn to Ukraine's allegation concerning the Mejlis. In its written submissions, the Russian Federation has duly described to you the real nature of that organization. It's based in Kiev, financed by Kiev, made up of 9 individuals living in Kiev who, with the support of Kiev, are self-proclaimed representatives of the Crimean Tatar community, of the Crimea in Russia. The time has now come for you to have a full image of what the Mejlis is as these proceedings are nearing their conclusion. Ukraine would have you believe in its false narrative according to which Russia has been oppressing the Crimean Tatar community and has targeted a peaceful representative body. That is incorrect. Russia has presented a number of testimonies from Crimean Tatars, including from former members of the Mejlis, which explain that the Mejlis was heavily involved in corruption, chaos and violence. They also show that the Mejlis did not represent the Crimean Tatar community. In 2014, its approval ratings didn't even get as high as 20%. Indeed, the Mejlis has done nothing to settle the problem of the mistreated Crimean Tatar community that it suffered under Ukrainian domination. In reality, the Crimean Tatars are well represented at all levels. There are over 30 organizations that represent some 30,000 Crimean Tatars. The Crimean Tatars are also represented in the elected bodies. In 2019, there were hundreds of them who were elected deputies. The Crimean Tatar Council is made up of eminent representatives of the Crimean Tatar community. There is also the Council for Inter-Ethnic and Interfaith Relations in Crimea, and what is more, a Council for Interethnic Relations that comes under the aegis of the Russian president. So Crimean Tatars are broadly represented in all of those bodies. Madam President, even if the Mejlis has enjoyed a certain amount of support at the outset, this was lost over the course of time when it embarked upon criminal and extremist activities. The entire history of the Mejlis has been marked by violence and provocation. In 1992, the Crimea was shaken by violent riots organized by the Mejlis. The leader of the Mejlis, Mustafa Dzhemilev, called for a massive mobilization of Crimean Tatars and the establishment of self-defense units, and he threatened to block the railways. As a consequence, the activities of the Mejlis were deemed to be unconstitutional, and that was decreed by the Ukraine itself in 1992. Over the course of time, the Mejlis and its leaders have never chosen to go down the avenue of peace and dialogue, but only issued ultimatums and embarked upon acts of violence. In this regard, I would respectfully refer you to paragraphs 144 to 167 of the Counter Memorial to see the detail of those events that occurred during the Ukrainian period of Crimea's history. In 2014, the Crimean Tatar Assembly, the Kurultai, decided to cooperate with the Russian authorities. The Mejlis, the function of which was to implement that decision, chose to ignore it. Ukraine itself stressed the vital importance of the Kurultai in its oral arguments on Monday, and it didn't challenge the fact that the Kurultai is not banned in Russia. Ukraine claims that Mejlis has been banned in order to target the Crimean Tatar community and deprive it of its political leadership, a sort of revenge, if you like, for its refusal to bend the knee before Russia. Even though this is an absurd assertion, it has at least the merit of showing that Ukraine does not believe that the ban of the Mejlis was decided on racial grounds. Even if Ukraine's far-fetched position were to be believed, this would be a question of politics and not of ethnicity. In reality, Ukraine does not take account of the overwhelming evidence that shows the real reasons for the decision to ban Mejlis. I'd like to cite a couple of cases, but there are a lot of others as well. These two cases are particularly relevant because they are at the very root of the legal decisions concerning the ban of the Mejlis. On the 3rd of May 2014, the Mejlis supporters attacked a border post at Armyansk in order to try to enter Crimea, using force against the border service officials. In 2015, there was the blockade of Crimea. Last week, I showed you some photographs of this blockade. Ukraine remained totally silent on this on Monday. The 2015 blockade was the inspiration of the Mejlis, and it was implemented by the Mejlis members, soon to be joined by the right sector neo-Nazi organization. Mr. Choborov never denied that he's one of the brains behind it. Mr. Lenor Islyamov, who's a close ally of the Mejlis, even referred to it in terms, using the term jihad. Those behind the blockade acknowledged that they had created a humanitarian catastrophe in Crimea. There was the energy blockade, but water supplies to Crimea were blockaded as well. That was the water blockade. They prevented transport vehicles from entering Crimean territory. That was the transport blockade. There was also a trade blockade that prevented the delivery of certain goods to Crimea. Let me also underscore that the energy blockade occurred in the month of November, when it was cold. Ukraine had not supplied gas to numerous Tatar households in Crimea, and people were frozen to the marrow. How can the Mejlis claim to represent the Crimean Tatars having done that to them? That is why in 2016, 5 Crimean Tatar organizations asked the Mejlis to explain itself. Madam President, that is the reason why the Mejlis was banned. There's absolutely no question of ethnicity that came into that decision. In the eyes of any reasonable person, it was extremism. Ukraine finds no further evidence for its allegation that the Mejlis ban was a breach of CERD. It was even pointed out that there was the anti-extremist law in 2016 that was the very basis for the ban on Mejlis. On Monday, Professor Coe asserted that far from justifying Russia's attempt to discriminate in the face of non-derogable norms, its national security law constitutes compelling evidence of Russia's discriminatory purpose as applied to Crimea. And in support of that erroneous statement, he relies on a statement taken out of context to say that certain international bodies stated that that law was vague and broad. Mr. Chikaya has shown that this assertion is unfounded. And for my part, I would add that this statement in no way concerns the ban of the Mejlis. Madam President, the list of extremist organizations that are banned in Russia has some 101 entries, of which 77 are pseudo-religious or Russian pseudo-nationalist. In 2016, 14 organizations were added to the list, including the Mejlis. These organizations share nothing, and there's no racial element in the addition that was made. Under Article 15, Paragraph 3 of the anti-extremist law of Russia, the Mejlis could and should have declared that it was against the extremist activities and declarations of its leaders, denying, in other words, all responsibility. The Mejlis did not do so. So, under the same law, it was deemed to be in support. And a decision was taken, legally founded, to ban it. By way of conclusion, I'd like to draw your attention to one last thing. Madam President, members of the court, before the hearing on the 5th of June, Mr. Chubarov posted something offensive on Facebook aimed at the Crimean Tatars, who are part of the Russian delegation, and you can see this on your screen. Is it worthy of the title representative? Madam President, members of the court, this brings me to the end of what I wanted to say about the Mejlis, and I'm now going to move on to education in Crimea.
As concerns this issue of education, Russia is putting forward figures, statistics, detailed statements, specific examples to confirm one simple fact. Education in Tatar and Ukrainian languages in Crimea is fully available. Tatar and Ukrainian language schools are operational and operating in Crimea. New textbooks are being printed, teachers in these mother tongues are being trained in Crimean universities. Ukraine has not disproved this, and after 2 rounds of pleadings, Ukraine has not given any convincing evidence that pupils, Crimean Tatars and Ukrainians, are denied any education in their mother tongue and are treated any differently from other ethnic groups. Ukraine says that the Russian Federation misinterpreted its Ukraine's claim on education. Again, Monday, the Council for Ukraine has claimed that Ukraine has never argued that there is a general right to education in a minority language in CERD. Ladies and gentlemen, this is your summary on the claim of Ukraine on education as you stated it in your order. And it says here, Ukraine further states that Article 5E5 of CERD provides for a broad right to education and training, which also covers the right to be educated in one's own native language. Now, if you go along with the statement made any number of times by Ukraine since the order was handed down, then this claim has been abandoned by Ukraine. So what still stands? According to Council for Ukraine, and I'll quote in English, it is sufficient to establish discrimination in violation of the CERD that Russia removed provision for existing minority language education from some ethnic groups and not from others. The Ukrainian claim has now shrunk to some vague and imprecise allegation, according to which Russia had removed educational resources that used to exist in Ukraine previously. But what were these educational resources in Ukraine, or in Crimea more specifically, before 2014? Look at the Crimean Tatar language. In its pleadings, Ukraine considers that Russia has erased the Crimean Tatar and Ukrainian languages from Crimea's schools. However, it has not at all looked at the issue of teaching and education in Crimean Tatar language, and for a good reason. First of all, the data submitted by the Russian Federation shows a general drop in the number of students and pupils studying in Crimean Tatar before 2014. As you can see it here, there are now more pupils than ever studying the Crimean Tatar language. Moreover, the witness for Ukraine, Yulia Tyshenko, also confirms that the Crimean Tatar has never really been an educational language in Ukraine. According to her, Crimean Tatar language was only studied as a separate subject. The normal languages of education were Russian and Ukrainian. The conclusion is therefore straightforward. Russia had nothing to remove, no resources to remove. As you can see here, you have photos from school number 44 from Simferopol, which teaches in Crimean Tatar. Local residents call it the Four Presidents School because it was started, or works to build it started in 1993, and 4 Ukrainian presidents never brought it to a close. Russia has spent 430 million rubles, that is some $7 million, to build that school. There are all sorts of educational activities that are also conducted in schools across Crimea to promote the Crimean Tatar language and culture. Since and after 2014, the Crimean Tatar schools were in fact teaching in Ukrainian. Look at the school number 20 in Theodosia, for instance, and the high school in Simferopol. The Russian Federation added to its counter-memorial and to its rejoinder a number of testimonies from staff in these schools and other witnesses. These show that schools in Crimea have the full possibility and are free to educate and teach in Ukrainian. Some indeed do so, but fewer and fewer parents see any relevance and interest in having their children study Ukrainian. The drop in the interest for Ukrainian in Crimea is related to a number of objective reasons, each of which has been explained in detail in Russia's writings. First of all, despite the attempts by the Ukrainian government to Ukrainize the peninsula, Ukrainian language was still unpopular and was only really necessary for those who wanted to have a career in the civil service or in the military, for which knowledge of the Ukrainian language was vital. Following the reunification of Crimea with the Russian Federation, this is no longer the case, and the number of pupils studying in Russian is back at its pre-Ukrainization level. Now re-establishes a balance between the natural needs in education in the peninsula, and this is fully covered by the current educational system. Secondly, since 2014, Crimean pupils now have far more opportunities to join and study in Russian universities, which international rankings show are more prestigious than Ukrainian universities. Thirdly, the Ukrainian authorities themselves have fueled the reluctance of people from Crimea to study in Ukrainian. In 2014, the Ukrainian Ministry of Education did not recognize the school-leaving certificates issued by schools in Crimea. Crimeans were therefore not able to study in Ukrainian universities. So it's not Russia that is removing the means to study Ukrainian, but Ukraine which is distancing itself from the students and pupils in Crimea who are studying Ukrainian. Having experienced so many such measures on the part of Ukraine, the interest of families to study Russian and the lack of demand for Ukrainian is perfectly understandable. Schools in Crimea host dozens of events promoting the language, Ukrainian culture and language, and this goes against any misleading statements made by Ukraine to the effect or relating to the erasure of Ukrainian culture and education. Let me come back to the Albanian schools mention that Ukraine has relied heavily in this case. This holding is directly applicable to this case, where equal access to Russian language education discriminates against Crimean Tatar and ethnic Ukrainians. In fact, that is the quote of a statement made by Ukraine, but that assertion is entirely wrong. The Russian Federation has shown that it is not discriminatory in Crimea. Not only have we education in Russian, but also in Crimean Tatar and Ukrainian, which are both official languages in the Republic of Crimea. And on Monday, we had no coherent response by Ukraine on this issue. We have shown that there is no analogy between the facts here and the Albanian schools case. Ukraine seems to have found an analogy, and on Monday they stated that as recently as May 2023, just last month, Russia reinforced the discriminatory effect of its educational measures by seizing and looting the last remnants of the Orthodox Church of Ukraine in Crimea, an institution whose private schools has long been seen as a mainstay of Ukrainian language teaching and culture in Crimea. Now, there was no evidence, not even a footnote put forward by Ukraine relating to this event. Quite clearly, the court cannot rely on such facts to find that racial discrimination has occurred. In fact, Ukraine has not established a discrimination, let alone a discriminatory campaign or an educational erasure of Ukrainians and Crimean Tatars. This shows that the allegations of Ukraine relating to education as a violation of CERD is unsubstantiated. Which brings me to my third point, Madam President, the enforcement and application of the law. On Monday, Ukraine went on stating that the Russian Federation had armed law enforcement against ethnic minorities. But Ukraine has still not been able, and hasn't done it since the beginning of the proceedings, to refute the simple fact according to which law enforcement measures were taken by Russia not on ethnicity, but on the grounds of presumed criminal activity. As concerns police searches and detentions, for instance, the allegation of counsels for Ukraine seemed to be, on Monday, the simple claim that, and I quote, more than 70 Crimean Tatar individuals have been imprisoned based solely on their alleged association with alleged extremist organizations. Even though the sources referred to by Ukraine does suggest that this statement is questionable, it does, however, confirm the position of Russia since the very beginning, that these repressive measures have been taken on the grounds of association with violent and extremist organizations, not on the ethnicity of individuals. The case of Mr. Server Mustafayev, a Crimean Tatar currently in prison for his involvement with Hizb ut-Tahrir, an extremist organization, is one example. Counsel for Ukraine have not denied that Mr. Mustafayev had links with the organization, an organization whose declared aim is the establishment of an Islamic caliphate and the enforcement of Sharia law across the world, and which has been banned in Russia since 2003. The court must also know that this organization has been banned in other states, and that this approach has been confirmed by the European Court of Human Rights. In fact, Ukraine is suggesting that to the courts that Russia is not entitled to identify threats to national security and to act accordingly. Ukraine also maintains that a government cannot tackle violence and extremist threat when individuals involved can be said to belong to a specific ethnic group. This argument is not just clearly erroneous here, as my colleague has shown. It is also particularly dangerous if it were to be given a broader application in international law. And that's an argument that states would never have agreed to when becoming parties to the Convention on Elimination of All Forms of Racial Discrimination.
Madame et Monsieur de la Cour.
Madam President, distinguished members of the Court, other individuals which Counsel for Ukraine sought to dwell upon yet again on Monday are those regarding purported disappearances, kidnappings, murders and torture. But these instances equally exemplify the fundamental weakness of Ukraine's arguments. For example, Mr. Gimblet stated that the purported kidnapping and murder of Mr. Shadamatov was a discriminatory act. Yet the Ukrainian authorities themselves, as we explained in our rejoinder, determined that Mr. Matov's death, in accordance with Ukrainian criminal law, was an intentional murder of a kidnapped individual and not an intentional murder motivated by racial, national or religious intolerance. For its part, the Russian Federation, which was in no manner implicated in the kidnapping of and murder of Mr. Amitov, made huge efforts to investigate this crime. As we explained in our memorials, Ukraine itself recognized that more than 270 witnesses were questioned by the Russian authorities, and that more than 50 forensic analyses and 50 examinations were conducted. Besides, Ukraine itself refused a request for legal assistance lodged by the Russian authorities in charge of the investigation into this incident, but it had the temerity to criticize Russia in this great Hall of Justice for the way in which it conducted the investigation. Let us not forget that Counsel for Ukraine recognized again on Monday that the court may have some difficulty in attributing these disappearances to Russia. It is also revealing that Mr. Gimblet only made one general reference to the attribution under Article 8 of the Articles on State Responsibility, without in any way mentioning Russia's arguments, which demonstrate that the criteria set out in that article can clearly not be satisfied in the case before us. Furthermore, Ukraine has not claimed Russia played the slightest part in the purported kidnapping of Mr. Chenkun, a Euromaidan militant Yet again, we have shown in detail that Russia conducted an in-depth investigation into that case, even if the alleged events occurred before the reunification of Crimea with Russia. In addition, Ukraine has sought to rely on the witness statement of Bishop Klimet, the Metropolitan of Simferopol and Crimea. But that statement does not suggest that Mr. Shenkun was kidnapped because of his ethnicity. Yet again, we see that although Ukraine has accused Russia of distortion and diversion in these proceedings, these terms can in fact only apply to Ukraine's allegations regarding this incident and others, and the manner in which it artificially brought the instant case before you. Might I add that Mr. Shenkun, according to social media, is alive and well and living in Kyiv. Madam President, distinguished members of the Court, upon closer scrutiny, it appears quite clearly that with regard to allegations of disappearances, murders, kidnappings and torture, Ukraine has not been able to prove the existence of numerous illustrative acts. It certainly was not able to prove that these purported acts are evidence of a pattern of behavior or a concerted campaign against the ethnic communities of Crimea. Monday, Professor Ko rather strikingly declared that Russia conceded or silently recognized most of these facts, which underlie Ukraine's allegations of CERD violations. Needless to say, nothing could be further from the truth. Ukraine's assertion is unfortunately just one example of the hyperbole and manipulation which have characterized Ukraine's arguments since the very beginning of this case. Ukraine seems to hope that such arguments will be upheld by your court. The Russian Federation hopes, and indeed declares, that international law should definitely be taken more seriously than that. Madam President, distinguished members of the Court, this brings me finally to the last part of my presentation. Madam President, distinguished members of the Court, I would like to come to Ukraine's allegation according to which the Russian Federation did not abide by the court's order on provisional measures delivered in April, 19th of April 2017. According to Ukraine, the Russian Federation has breached the three measures indicated by the court. But I've just shown that the sweeping allegation of Ukraine regarding education must be rejected by the court. Equally, Ukraine's claim regarding a breach of the court's order must be rejected. Regarding the purported violation regarding the aggravation of the dispute contained in the court's order, I would like to say words about this, and then this will conclude my presentation. Ukraine has emphasized events which took place as of February 1922, but this bears no relationship whatever with the present proceedings. In your 19th of April 2017 order, you said expressly that the case of which the court is seized is of limited scope. Besides, Ukraine itself has brought a separate case before the court regarding the events which occurred as of February 2022, invoking the Convention of the Prevention and the Suppression of the Crime of Genocide. Whereas Ukraine has described Russia's conduct as making more difficult the settling of the dispute before you, it is a fact that the Russian Federation has actively sought a negotiated settlement between the parties in this case. In its response, Ukraine has called this proposal inappropriate. We had to remind it that in our rejoinder, the court itself, which the court itself has said, and pending a decision of the court on the merits, any negotiation between the parties with view to achieving a direct and amicable settlement is to be welcomed, quote unquote. Madam President, distinguished members of the court, I can but repeat that the Russian Federation has taken significant measures at all levels of its administration to comply with your order. The allegation according which the order has not been respected simply cannot be upheld. And this brings me to the end of my submission. I thank you for your kind attention, and I would ask you, Madam President, to give the floor to Maître Jean-Charles Chikaya. Thank you.
I thank Professor Azari, and I now invite Professor Chikaya to address the court. You have the floor, Professor.
Madam President, I'd like to thank you because I stand before this court once again once we've gone beyond the allotted speaking time for Russia. I shall keep it short. That's the least I can do, you'll probably say, because there's nothing significant that's been said by our opponents as regards the section I'll be dealing with here. In other words, the question of citizenship, media, public events and cultural heritage. First of all, we'll see that Council for Ukraine tried to differentiate between this case and that of Qatar versus the United Arab Emirates and said, and I quote, that that case concerned a distinct legal question, namely whether discrimination based on a person's current nationality falls within the prohibition of racial discrimination within the meaning of the Convention. It did not address the discriminatory downstream effects of a forced citizenship regime on a third protected group, the issue appropriately before this court. End of quotation. Now, this description of the question, which I should say was dealt with in the 2021 judgment, is wrong. Aside from the question mentioned by Ukraine, the court ruled on whether the measures qualified by Qatar as indirect discrimination directed at Qatari citizens falls within the scope of the Convention. This question is clearly similar to the question of deciding whether the alleged downstream effects of a given citizenship regime on a third protected group fall within the scope of the Convention. Such effects, as stated very clearly by the court, cannot be based on a proscribed distinction. Rather, they would stem from a differentiation made on the basis of citizenship, which is not provided for by CERD as a forbidden basis for distinction or exclusion. Clearly, the goal of Ukraine is to use the term downstream effects in order to describe what is an actual fact, collateral or secondary effect. In this context, the judgment in Qatar versus United Arab Emirates cannot be separated from the question before you today, and there is no need to deviate from jurisprudence. Secondly, Ukraine continues to use the term forced citizenship in order to describe the citizenship regime applicable in Crimea without giving any answer, any response to our arguments on that matter. It should be said once again that in no way is that regime forced. On the contrary, it is compatible, as has already been explained by Russia, with that provided for by the European Convention on Nationality and the Articles of the International Law Commission, and also the recommended approach by the United Nations General Assembly addressed to all states. On this matter, I would, with all due respect, refer you to the written submissions in paragraphs 410 to 424 of our rejoinder for further detail. Thirdly, Ukraine did not mention citizenship in its final conclusions. And here I'd like to refer to the court's decision in the asylum case, and I quote, "One must bear in mind the principle that it is the duty of the court not only to reply to the questions as stated in the final submissions of the parties, but also to abstain from deciding points not included in those submissions." End of quotation. If Ukraine's conclusions are not sufficiently precise as to the question of citizenship, they cannot be the basis for any application or claim for remedy. Now, on the media, we see that Ukraine continues to ignore all evidence submitted by Russia. Instead of responding seriously, Ukraine continues to repeat empty slogans devoid of any credible justification. Russia has demonstrated in its written submissions that there are at least 65 media outlets in Crimea working in the Tatar and Ukrainian languages. Ukraine has been unable to challenge or disprove that simple fact. But Council for Ukraine attempted to target a TV channel Millet, describing it as a propaganda tool allegedly created by the Russian Federation to replace the independent Tatar media. That is absolutely false. There is no censorship or propaganda on the Millet channel, as has been confirmed by one of its former employees. We would respectfully invite you to refer to paragraph 1191 to paragraph 1195 of the rejoinder, and also Annex 498 of the counter memorial, where you will find detailed information concerning the Millet TV programs. Ukraine's argument is in fact limited to the fact that Millet receives financing from Russia. But it should be underscored that the only Tatar channel in Ukraine, ATR TV, that Ukraine contrasts with Millet is financed by the Ukrainian government. And when the financing of ATR 25 came to a halt in 2021, the channel stopped broadcasting.
Which brings me to public events. Ukraine is still going on and doing the same thing, namely ignoring the evidence submitted by Russia that shows conclusively that there is no differentiated treatment against specific ethnic groups. Ukraine has not disputed that a number of public events has been successfully organized by the Tatar and Ukrainian communities, including Surgun and the celebration of the birthday of Taras Shevchenko. In its statement on Monday, Council for Ukraine strangely stated that Ukraine had decided to supply comparators to establish racial discrimination where, and I quote, it makes sense to do so, end quote, while referring to the organization of public events. But Ukraine has, in fact, not referred to any comparators, showing that Russia treated the Tatar and Ukrainian communities differently on such public events. As concerns public events banned in the past, the only reason for that was that the organisers had not complied with the administrative rules set by local authorities, and no measure clearly was taken on the grounds of ethnicity, the ethnicity of organisers. Lastly, as concerns cultural heritage, there again, there is no response on the part of Ukraine. Russia, for instance, has chosen to show the court pictures of a number of cultural events freely being held in Crimea by way of illustration. But in those instances, Ukraine has only seen these pictures and seen in those pictures a Russian flag as the backdrop. Just to, in a way, express its own obsession. I'm sure that Ukraine will excuse me for showing this once again. You can see that those celebrate the birthday of Taras Shevchenko, the great author. So this clearly illustrates that these celebrations are still happening in Crimea, without any restriction imposed by the Russian authorities. And as you can see, it's not only the Ukrainians that are celebrating this, but also Crimeans of Russian descent, which pay tribute to this great poet. And if you, with your leave, Madam President, and with the leave of Russia, I will finish with a quote. I'll softly pray that God may grant to us that all the Slavs may brothers be. Madam President, ladies and gentlemen of the court, thank you for your attention. Can I respectfully request that you give the floor to the agent of Russia, His Excellency, Mr. Alexander Shulgin, to read out the Russian Federation's final conclusions. Thank you.
Professor Chikaya, and I now give the floor to His Excellency Mr. Alexander Shulgin, the agent of the Russian Federation. You have the floor, Excellency.
Madam President, members of the court, it's an honor for me to conclude the presentation of Russia's position and deliver its final submission. We have listened to Ukrainians' extensive oral pleadings, and we have been exchanging procedural papers in this case for 6 years. Now, it is more than obvious that Ukraine decided to misuse two important multilateral conventions, the ICSFT and the CERD, for its own political purposes. On the basis of the ICSFT, Ukraine seeks to brand the people of Donbas as terrorists, and the DPR and the LPR as terrorist organizations. In support, it basically relies on several selling incidents taken out of the context of the bloody armed conflict which Kiev has unleashed and pursued for all these years. Ukraine wants you to forget that it shelled and bombed the people of Donbas. It wishes you to forget that people of Donbas for years were subjected to blockade that brought them to the brink of the survival. Ukraine also seeks to exploit the tragedy of MH17. Moreover, in support of its allegations, Ukraine relies on fake evidence and threatens those who reveal the deceit. According to Ukraine, Russia somehow had an obligation to cooperate on the basis of speculative allegations that are supported by no one and cannot be proven to be terrorism even after 6 years of legal proceedings before this court. Ukraine devised this narrative in order to justify its war against Donbas, its violations and subsequent rejection of the Minsk agreements that led to the current armed conflict. Now it seeks to have this court's decision behind these heinous actions. Ukraine also attempts to misuse the CERD in order to accuse Russia of a fictitious apartheid-like regime in Crimea. The only support it has are just big, empty words regarding, I quote, tens of thousands of victims, unquote, and statements of extremists that have engaged in water, energy, and trade blockade of Crimea. Extremists that are rejected by their own people in Crimea, who call them traitors. Ukraine has the audacity to request this court to install these extremists and their organization as a representative organ of Crimean Tatars in Crimea. They seek to have this court's decision behind Mr. Chubarov, who threatens Crimean Tatars from this very courtroom. Ukraine has hypocritically requested court's protection on behalf of people of Donbas and Crimea. But these people do not need and have not asked for Ukraine's protection. They have chosen different destiny. What Ukraine means by that protection is more than evident from misanthropic statements of its high-level officials and blatant armed attacks. It is also clear that Ukraine has pursued these proceedings in order to distract world's attention from its own dealings, its state support for Nazi organizations and leaders, its suppression of Russian language and culture, as well as disdain For any other ethnic minorities, Ukraine came to this court with dirty and bloody hands. Ukraine uses this courtroom in order to project its false narratives. In its imagination, it has already won this case. Its submissions take the form of orders to this court and international community. However, Russia believes that this court will see the reality beyond the maze of artificial arguments and misrepresentation of facts, beyond pressure and myriads of political decisions. This is, at the end of the day, the role of chief judicial organ of the United Nations. Madam President, distinguished members of the court, in conclusion, I present to you the final submissions of the Russian Federation. For the reasons explained in its written submissions and developed further during the oral hearings, and for any other reasons that the court may deem appropriate, the Russian Federation respectfully requests the court, first, to dismiss all the claims that Ukraine made under the International Convention for the Suppression of the Financing of Terrorism, and second, to dismiss all the claims that Ukraine made under the International Convention on the elimination of all forms of racial discrimination. Madam President, distinguished members of the court, I thank you for your kind attention. I would also like to take the opportunity to thank all members of the registry and interpreters for their dedicated work throughout the hearings. This concludes the oral argument of the Russian Federation. Thank you.
I thank the agent of the Russian Federation. The court takes note of the final submissions that you have just read out on behalf of your government. This brings us to the end of the hearings in the case concerning application of the International Convention for the Suppression of the Financing of Terrorism and of the International Convention on the Elimination of All Forms of Racial Discrimination, Ukraine versus Russian Federation. I thank the representatives of the two parties for the assistance they have given the court by their presentations in the course of these hearings. In accordance with practice, I shall request the agents of the parties to remain at the court's disposal to provide any additional information it may require. The court will now retire for deliberation. The agents of the parties will be advised in due course as to the date on which the court will deliver its judgment. As the court has no other business before it, the sitting is now closed.